Monday, January the 14th, 2013. It's the first meeting of this new year. Welcome back, everyone. Glad to have you here. Before we get started with the call to order, roll call, and all like that, we have three distinguished guests with us this morning. And I'm going to ask Nicole, would you mind introducing our guests, please?
Yes, we have distinguished guests today are from the Appraisal Subcommittee. We have Denise Gray, Executive Director, and Christy Clement is our Policy Manager. I think she's our official head Policy Manager. And Claire Brooks is our official trainee in process, and she's the administrator for the regulatory affairs. It makes you sound like
I know.
Well, we want to welcome y'all to Nashville and the commission meeting. If y'all have any questions, we'll be more than glad to try to answer them for you. And if it gets too complicated, we'll defer to our executive director. Okay. Okay, we call to order. Roll call. Again, Mr. Jason Covington. Go ahead.
Jason Covington, Nashville, Tennessee.
Rosie Johnson, Paris.
Ed Varolo, Johnson City.
Nancy Rogersville.
Norman Hall, Brentwood, Tennessee.
Tim Walton, Collierville, Tennessee.
Herbert Phillips, Nashville.
Mark Johnstone, Jackson, Tennessee.
Michael Green, Johnson City.
Okay, the first thing we need to do is to adopt the agenda with the right to move items that might become necessary. Can I get a second to that? Motion. Motion second, all in favor say aye.
Aye.
Next order is to adopt the Roberts Rules of Order for 2013. Do I hear a motion?
I'll make a motion.
I have a motion from Mr. Herb Phillips.
Second.
Second, Nancy Point. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, like sign. I believe all of y'all have a conflict of interest form you're supposed to have formed, or signed, or will be signing. Does everybody have that there in front of them? If not, make sure you sign that and get it back to Nicole before we leave today. Okay, we need a review and approval of the December commission meeting.
Motion to approve.
Got a motion to approve, Mr. Johnstone. Do I hear a second?
Second.
Got a second, Mr. Covington. Any discussion on those? Hearing none, all in favor say aye.
Aye.
Opposed, like sign. Approved. Okay. Experience review. That'll be at this point.
I would like to recommend that we approve my interviewee this morning for his reports so we can proceed forward. That's Mr. Brewer.
You got a motion?
Yes. Do a second.
That's it.
Got a second, Mr. Phillips. Discussion. Hearing none, all in favor say aye.
Aye.
Like sign. Approved. Dr. Varela?
Mr. Hall,
Yes.
there's a second item on the experience interviews.
Recommendation?
Yeah, there's Richard Hinkle. He wasn't interviewed, but he made an application request for experience waiver.
Okay.
So Richard Hinkle initially applied to upgrade from registered trainee to become a licensed real estate appraiser in October of 2011. He participated in an experience interview with Mr. Phillips at that time, and the commission voted in November of 2011 to approve his experience. On November 16, 2011, Mr. Hinkle received his notification of approval to take the LI exam. The letter indicated the applicant may have up to 4 attempts in a 12-month period to take the test. Mr. Hinkle indicated in a letter dated December 18, 2012, which he submitted with a new application, that he failed to pass the examination. He's requested that the commission waive a second experience interview and that he be approved to go take the exam again.
And he's already taken 4 times, is that correct?
He took it, yes, he took the test in 2011, or in the beginning of the first part of 2012, but his approval period has expired. He's applied under a new application. He submitted an experience log with it, so the commission has the ability to either require him to do a second experience interview or to waive it. Rule 1255.01.4 says each applicant shall complete all application and examination requirements within 1 year of the date the commission grants approval for the applicant to take the required examination. An applicant may not take the required examination more than 4 times within 1 year period following approval. Thereafter, an applicant wishing to take the required examination shall reapply and submit a new application fee. The commission may grant exceptions to the requirements set forth in this paragraph upon appropriate individual request.
Did his letter indicate that he had only tried to take it one time in that year period? Even though he had 4 opportunities, he was given 4 opportunities, he only took 1.
I think he tried all 4 times, and I think he failed at 4 times. It says, I have made 4 attempts at the exam. I have failed the last 3 tests scoring between 70 and 73, needing a score of 75 to pass.
What is the commission like to do? We have a motion as to what to accept this gentleman's request. What?
So I got lost in it. He's within a year. He's tried 4 times. Wants to take it again within the second year.
No, he wants to take it again, really would be in 2013 now, so we've got another year period. So he'd have 4 more attempts really in 2013 to take this exam, without coming back in for an experience review. That's the way I understand it. Is that correct?
His 1 year period lapsed. We make him wait for that whole thing before they can even reapply again. So he had 1 year from 2011 to 2012 to take that test. He failed it. He's applied again. He's asking to not do it. He submitted an experience log, and we'll do the experience log and interview at the next commission meeting if the commission decides that he needs to do another experience interview, but has asked that you waive it.
I have a question. What was his education? Where did he get his education? What I'm concerned about is maybe we need to say, we'll let you take the exam, but for your own good, don't you think you ought to take another course, whatever it is you think you're weak in? Because my concern is, you know, if he's not going to take any other course, just keep taking the exam, I have a problem with that. And it could be ways taking his courses, he's not getting the education, even though that provider is approved by the commission.
Mr. Chairman, I don't think he's debating, I don't think he's debating whether he can take the test again. I think he can take that, right?
No.
The commission has to give approval for any applicant to take a test. It's part of the application process. Whether or not he has to do the experience interview is the question at hand. To answer Mr. Hall's question, he took about half of his education at the Appraisal Institute and the other half at Trees. Whether or not he passes it in the next year, 4 attempts, that's still on the applicant. You know, I don't think that it would be the obvious would escape his attention that he should probably take a class or, you know, do some exam prep before he goes to try to take it again.
If I read this correctly, you recommended that we go ahead and approve him to take the exam. Is that correct?
I think the question is,
To waive the experience interview is my recommendation.
Correct.
We'll go ahead and Mr. Phillips interviewed him once already.
Do I hear a motion?
I move that we ask him to re-interview for his experience.
Do we have a second for that?
I'll second that.
You got a second? Do we have discussion?
Mr. Chairman, one benefit to the experience interview will not be so much as to penalize him or say you need to do this or you need to do that, but perhaps to help him understand where he's deficient in the exams and maybe be able to give him some guidance so he can pass it the next time. That was my reasoning for seconding that.
Anybody else have any comments?
you know, we need to look at the, when we interview, you know, you interview the training, but at the same time, the information that he's been putting before you is probably done by, most of our sponsors, and he participated in it. So I'm just wondering if we're having a problem with that. Are we really seeing the sponsors work? We're seeing the trainees work when we interview. And if so, I think when he comes back to interview, I think that needs to be explored.
Did you have anything else? I'm sorry.
No, that's right. No.
Do we have any information about his exam scores and where he was gone and where he was? And maybe we can ask for specific experience that addresses his strengths and weaknesses too.
The applicant gets a score sheet when they take the test. Whether they pass or fail, they get a printout. I can see it. I can log into the PSI website to see that information. However, as a matter of practice, I tend not to. It's not particularly relevant to the office as to what someone does. I try actually to tell trainees, go in to take the test. It's just you and that computer. Try not to stress yourself out, because that's actually a way to fail the test, is to go in there and freak yourself out while trying to take the test. But, so it does identify percentage-wise, not specific numbers. The problem is a lot of people who take the test don't know how the psychometrics of the exam work. There's 160 questions on the test, and 150 of them count. Which 150 count the applicant doesn't know. That's strictly part of the examination provider's data. There's always 10 questions in there that they're sort of testing, and just seeing how people are doing on those particular 10 questions. And then the percentages are based again on the psychometric tested results. So if you think, like an applicant would think if you get on let's say it's a 100-question test, if I get 75 right, I'm going to pass the test. Well, actually, it may not be. In one test, you may have to score 80 to pass. On the other one, you might have to score 65 to pass, depending on the difficulty of the exam. Those are all weighted scores. So the strict percentages, how close he's gotten is something that is really going to be known.
Mr. Chairman?
Yep. Mr. Kevin?
I guess a couple of thoughts that I have is going back to the sponsor. Is he, what is he retaining from a sponsor? What level? Who is his sponsor? Do we have any background on him? Is that relevant? Secondly, like Ms. Havers pointed out, I'm not a good test taker myself, especially when you sit down in front of a new environment with this computer and all the things she just explained. And to answer Mr. Green's question, I think he scored a 72 and a 73, and the 75 is what he needed. So, I mean, he's right there. So, basically just comments to add. I don't know.
Anybody else? Mr. Johnston?
Mr. Chairman, I'd like to ask Director Avers, where does Mr. Hinkle live? Is he in Nashville, or is he in Memphis or Chattanooga? And the reason I ask that, could this interview, since he's already been in once, could Mr. Green or someone perhaps talk to him over the phone rather than having him come all the way to Nashville and maybe try to help address some of the concerns that we have? So, number one, where's he from? And number two, is there anything in our law that would prohibit that from being done?
One-on-one interview, I don't think there's anything that prohibits a commission member from having a conversation on the phone with an applicant. Certainly that commission member would have to recuse from vote on the matter, make a recommendation. Mr. Hinkle lives in Clarksville. I don't know. He hasn't objected to driving up here. I don't think he really cares what he does the experience interview again. It was more of a delay thing. He just wants to go and take the test.
Maybe he would like to voluntarily submit experience that in his weakest areas.
The exam score sheets sort of show you where your weak areas are. Like it's broken down into categories like sales comparison, use path, income. It's broken into categories, and you'll see whether you're passing or failing the category. And many of the applicants go in studying really hard for a particular category. To my experience as a teacher, a lot of students would cram the night before an exam for the math and do okay on the math, but they would do terrible on use path. It wasn't the math questions that would get them, and they would just get stuck on the non-math questions. If they're not identifying that for themselves, that's the issue. I don't know Mr. Hinkle's weak area. To a certain degree, we have 240 some trainees. I don't know if we can identify everyone's weak areas. The experience interview might be the right thing for this applicant if he's having such a hard time. You can walk through and see if there's anything in his appraisals that are showing it. He just may be a rotten test taker. Who knows? I don't know what the deficiency is. I really don't. And there's a lot of trainees who've called me and just said, I'm a good appraiser, but I'm a terrible test taker. And I think that's a common.
We have a motion on the floor to require another experience review before we make a decision as to grant him the opportunity to take the exam again. Any more discussion on that? All in favor of the motion, signify by saying aye. Aye. Opposed? Ayes have it. Next item of business, Ms. Avis, is this application review of Curtis Brian Bearden?
The next item was the educational report.
Okay, Dr. Barella?
Thank you, Mr. Chairman. For the education report today, we have 4 courses from Dennis Badger and Associates, 16, 25, 26, 27, and 28. They've requested 3.5 hours continuing education for each of those courses. As noted on the report, I was advised that we can't approve 1.5 hour credits in our renewal system, so I would recommend for 3 hours in each of those instances. And subsequent to that, there was also an instructor approval request for Mr. Hoover to teach courses 1481, 1578, and 1579 for Dennis Badger and Associates, 3 continuing education courses, and I would recommend for that as well.
Okay, do I have a second?
Second.
A second. Discussion?
Dr. Brill, I'd like to ask you, on the 3.5 hours courses, of course you say you can't improve a half an hour.
Yeah.
Why did you go down 3 instead of going up to 4?
I went to the hours and I couldn't make 4 out of it. And in reality, if you're looking at what they're asking for is 3.5, I'm not sure that we can go and say, well, we'll give you 4. We'll give you more than what you're asking for. But I did look at the hours and tried to see if we could make it out of 4.
Yeah, I think what Mr. Badge is trying to accomplish here is to get 7 hours in one day. And I would hate to go and stay all day for 6 hours and then you got 1 hour left. It's hardly going to find. 1 hour, you have to go and take maybe 3 hour, 4 hour courses to get 1 hour. And I think what he's trying to do is trying to get them to get maybe 14 hours in a couple of days.
Unfortunately, this is a deficiency in our licensing system.
Yeah.
We have a really old antiquated licensing system, and it won't physically let me put in 3.5.
Yeah, I understand that.
And as much as I want to not put in an automated hour, I don't know how I would put it in and monitor it on a continuing basis if we round, if I don't put it in as 3, how would I know? And then what if the student didn't take both parts? Our continuing education hours, you have to attend 50 minutes out of an hour to get credit for 1 hour, and I think there's a little bit more than 50 minutes because of the extra half hour, but it's not 4 hours worth. The reciprocal licensees will get the benefit of getting the 7 hours probably because they'll attend both parts. I can put them in as miscellaneous hours, put one in as 3 and one in as 4. But our resident licensees, I don't think I'll be able to do that. It's just an unfortunate licensing system. We are working on getting a new licensing system, computer-based licensing system, which hopefully will be implemented in the next 2 years. And I just don't know how I'd monitor courses. This isn't the first time it's come up. We've had other courses where essentially we had to round down because of our deficiency in our system. But we just don't have the ability to put in half hours on our reports. Sorry.
Well, Dr. Brewer, would you have opportunity to maybe redo these courses where you have 4 and 1 and 3 and 0?
Yeah, that's a good idea.
Yeah.
If you would like to make that motion, I would certainly support that. By all means, if you would like to
You get back with
go
them
back.
and
Yeah, that's fine with me.
because it's going to be hard pressed to get people to come through. 6 hours.
Yeah, I don't have any problem with that at all. I realize it's sort of a system problem more than a course provider problem. So yeah, by all means, if the commission is willing to support that, yeah, that would be fine. If they want to go back and rejigger them.
Do I hear a motion?
Can I recommend that we approve it as the 3 hours, and then I'll put in notes on each one of them that he can resubmit for 4/3 approval without paying an additional application fee, and we just represent without a fee for the courses.
Yeah, that's fine with me.
And that way it gets him approved, because I know he wanted to offer the courses very soon, but I think in the next 30 days, and I wouldn't want to hold up his approval just hanging on.
Okay, we have
1 hour.
have a motion. All those in favor say aye.
Aye.
Opposed, like sign. Dr. Rowe, who is Dennis Badger and Associates?
I don't know who they are formally, but I know that they've done a lot of work with us, and they generally put in some really good quality information and courses. I don't know them personally.
I just never heard of them. I just wondered who they
They've
were.
come through quite a few over the last time that I've been here.
I've had their courses and they're excellent.
Yeah.
It's on the Appraisal Foundation.
They're based out of Kentucky.
Huh?
Kentucky.
Okay, I just did not know who they were, and that's not meant as a negative question, it's been an informative question.
Yeah,
You know, me, I'm
there's a
saying.
couple of them that come through pretty consistently with good courses.
But once again, I have no problem as long as everybody or somebody knows, who they are, what their
Yeah.
reputation is, something like that. Okay. All right. Next item would be the application review.
Thank you. Curtis Brian Bearden submitted an application to become a certified general appraiser based on reciprocity with the state of Georgia. It was received by staff. Mr. Bearden also holds a credential in the state of North Carolina, which was also granted through reciprocity. The application includes marking yes to character question number 1 on the application, which reads in part, have you ever been denied an appraiser license or certificate, or had an appraiser license or certificate or professional license of any type disciplined in Tennessee or elsewhere? Mr. Bearden has 2 disciplinary actions in Georgia, one dated February 16, 2012, and the other one was dated December 7, 2004. He indicated his first disciplinary action was when he was new to the appraisal profession, and he indicated it was an error in judgment on his part and poor training from his former supervisor. The second disciplinary matter he thought was not actual or public discipline at the time. He indicated that he disputes the facts in the agreed to, he indicated that he disputes the facts agreed to in the order. He concluded that since the discipline, he has continued his education as a candidate for designation with the Appraisal Institute. This matter was brought before the Commission because of the recent disciplinary action history of the applicant. Commission policy number 5 indicates the director may bring any application before the Commission for consideration. It is not the intention of the director to bring the matter for consideration of the facts included in the consent order and whether the applicant should or should not have been disciplined in either matter in Georgia. Director recommends approval of the application for certification based on reciprocity as the applicant has credential in good standing at this time in Georgia. The reason I'm bringing it is because most of the matters say our policy, if it's within 5 years, definitely needs to go to the Commission, and this is disciplinary action of a licensee within 5 years, so I wanted to bring it to your attention to decide.
Mr. Chairman, I move to approve Mr. Curtis Brian Bearden's application
Okay.
for certification.
We have a second.
I'll say.
Got a second, Mr. Green. Discussion. Hearing none, all in favor say aye.
Aye.
Opposed, like sign. Is that learned attorney now available?
I've been ready. Okay.
All right.
This report's kind of lengthy, so just bear with me. If you have questions, just call me whenever.
Before we get started, Nicole,
Yes, sir.
I noticed there's a thing in here from Michael Falcon about course renewal. Will we discuss that now or later?
It's
Later?
it's on the agenda, but a little bit lower down
Okay.
the agenda after the director's report.
Okay, that's fine. It was next to my packet, yeah, I just want to make sure I won't overlook anything.
That's okay. No, we can handle it at your pleasure, but
No, that's
Okay.
fine. That's fine. Okay, go ahead.
Okay, so the first item is 2012-013-811. This complaint was filed by a mortgage lender and alleged that the respondent communicated a misleading appraisal of a manufactured house by failing to report pertinent data and failing to appropriately select and analyze sales data, which caused a significant overvaluation of the property. The respondent sent a response stating, after receiving notice of the complaint, he searched his files on the subject property without success. The respondent also indicated that in accordance with provision allowed in the use tax ethics rule on record keeping, the files were destroyed shortly after the requisite 5-year period. The respondent explained that he attempted to travel to the location of
second? Okay, a second by Mr. Covington. Do we get discussion? Mr. Johnstone?
Kind of a point of clarification from legal, please. A closure with the letter of warning, I guess I'm looking at it from a disciplinary standpoint. A letter of caution, letter of warning, are those both considered disciplinary actions that would be in his file? Or those I guess the reason I think of that, I think back to the preceding discussion we had from the gentleman from Georgia, where he had agreed to some action and was thinking it was non-disciplinary when it ended up being disciplinary. And that could have been lack of counsel from his attorney or whatever. I'm not sure about how that occurred. But I guess my question is, when those go into a file, do they count as disciplinary actions if something were to happen in the future? Or is it just something that's in there, and if another case came forward, you would say there's been no action taken?
No, if we send out a letter of warning, then let's say a couple months down the road, this same person has issues. We would note that in the file they'd already been sent a letter of warning, so that would be used sort of, I don't want to say as an aggravating factor, but it would certainly be considered for the disciplinary action in the next case.
Does a letter of caution work in that same regards?
It does. I just normally say letter of warning because that's normally what I do. To me, it's kind of the same thing. But if you would rather it be stated more as letter of caution, then I don't have a problem with that.
Well, I guess my concern is, when you have someone that has a clean record for many years, no problems, and then you have a complaint that's filed 7 years after the date, and the file is not even required under use map to be kept, and you just look at all the surrounding circumstances, and sometimes it gets a little concerning that, are you going to put something in someone's file that it's going to impact him from now on, when he gets E&O insurance, when he reapplies for licensing, when he does, and I'm not advocating to be soft on violations. I'm just saying that as I look through these, and we have 30 violations, we have or 30 complaints, and then we have 30 disciplinary actions. So that's 100% disciplinary action ratios. Surely 1 out of 31 might not be anything wrong with it. I don't know. I'm just trying to get a handle on it.
I'm sorry.
Letters of warning, caution, instruction are not considered disciplinary action matters. They're not reported on the disciplinary action report, and they're not public discipline. As to whether or not it is maintained, it is. All of these are public records. So if someone knew to ask for the complaint file and asked for a copy of the letter of warning, yes, they could get a copy of it. But on the outset, the only people who get a copy of it are the respondents and complainant.
So would they be violating when they come up for renewal or reciprocity or E&O insurance, and if there's a question on there that says, have you ever had any disciplinary action, then they can, with clear conscience, put no.
No.
With an instruction, caution, or warning letter.
Right, unless the question very clearly said, have you ever been warned?
Well, I think that's important to get that. That might be a nice newsletter article, because I think there's a lot of misconception out there about those issues.
I think Ms. Johnson and Ms. Point are on the newsletter. So I think
You might be waiting a long time to get one. You turned down my last article. I'm not
the closure, dismissal, and letters of warning, caution, and instructions are not disciplinary. Consent orders are disciplinary action, and you're notified, and you have to agree to a consent order. Agreed orders are also disciplinary action, and then of course final orders are disciplinary actions.
Okay, at this point.
Mr. Chairman, I'd like to know if this was more than 5 years past, why we even had a review done on it. I know you have to open a file and you have to respond to it, but if it's been 5 years and the person doesn't have to maintain their file, why are we doing a review on it? Period. It seems a little excess.
The subcommittee might be able to, members might be able to speak to this more, but we are charged with
Opening
protecting the
file, I know
public,
that.
and we may not receive complaint files in a timely fashion. The burden of proof is always on the state for proving a violation of any state law, rule, or use path. So when a complaint file or an effective date on an appraisal gets to be older, it certainly becomes more difficult to prove something. And the respondent doesn't have to prove anything. The respondent can, say nothing and prove nothing, and the burden is on the state to prove that they violated the law. The benefit is that most of the information is contained in an appraisal report, so we reviewed it for compliance with use path. Some stuff is fairly evident, like like item number 1, where it says there's no statement in there as to what efforts were made to obtain a sales contract. Apparently the reviewer found that there was no information on that in the appraisal report, and that's a reporting requirement. You don't have to go too far to prove that because it wasn't in the appraisal report. So it certainly behooves us to tell a respondent this should be in your appraisal report. If nothing else, so that he doesn't do it on a current appraisal. That's why. There's no statute of limitations.
And I think sometimes when you send things out for review or process the complaint all the way through, other matters come to light that wouldn't have to. It was just based on what the complaint stated.
So
I understand what you're saying.
So there is no statute of limitations, right?
It makes sense, though, what you're saying makes sense, but I think sometimes that other things are brought to light that we wouldn't know about if we just went based on specifically what was in. Right.
Number of years.
The older it gets, the more difficult it becomes to prove. Certainly.
I reckon maybe that's what Mark is concerned about. Here we are 7 years after the fact, trying to go back and prove something, or disprove something. And I can understand his concern. Mark?
Call for the previous question.
Okay, previous question was to go ahead and accept closure with a letter of warning. That was Mike Green.
I have a question before we ask a question.
Yes.
Would you rather we word that as a letter of caution, or, do you have a problem? I don't have a problem with it.
Well, it's not my motion. I would have to amend that, and he would have to accept it as a friendly amendment, or we could vote on his amendment. And so at this
May
point,
I make a suggestion? If you withdraw your second, I'm sure Mr. Green will withdraw his motion and start all over again.
Mr. Green made the motion, Mr. Covington made the second.
Mr. Covington? Mr. Green? Okay, Mr. Johnson, you want to make a motion?
You certainly don't have to, but I just want to know.
well, my initial response would be I would dismiss with closure, but there are some things in there that need some instruction.
Call it a letter of instruction.
So I would move that we have a letter of instruction.
That's it.
Okay, we've got a motion and a second for a letter with instruction. Is that correct, Mr. Johnstone? A letter with instruction?
Yes.
Everybody understand the motion? Second, discussion. Hearing none, all in favor say aye.
Aye.
Opposed, like sign. Next.
Item number 2, 2012011871. This complaint was filed by a government-sponsored enterprise and alleged that respondent communicated a misleading residential appraisal report by misreporting the locations of 3 comparable sales, indicating they were closer to the subject property, failing to verify GLA of the comparable sales, failing to support adjustments made, failing to adequately summarize neighborhood information, and failing to support the cost approach. The respondent sends a very lengthy response stating summarily that he has been performing appraisals in the area for over 34 years and has more than a working knowledge of the area. In addition, the respondent indicated that none of the comparable sales he considered in the appraisal report were within the city limits that were alleged by complainant in the complaint. The respondent also stated that the cost approach was completed for the subject property and that the cost approach was given some weight, however the greatest weight was given to the market approach to value. The reviewer conclusions were that the neighborhood section lacked information was lacking in completeness and credibility due to the report errors by respondent. The reviewer noted that the appropriate appraisal methods and techniques were not developed by respondent. As such, council recommends the authorization of the civil penalty in the amount of $500 to be settled by consent order or formal hearing. No additional education recommended because the education from the prior consent order was taken in 2012, which was after the effective date of the appraisal of this report.
We've heard the recommendation. Do you have a motion?
I'll make a motion.
Got a motion from Ms. Stokes. Do I hear a second?
Second.
Second. Ms. Johnson. Discussion.
All right, I can't. I just, I think those are gray, subjective reviewers' comments. I really do. Maybe it's not our position to debate these here and now. Maybe that's for a hearing. I hate to see this go to a hearing. I hate to see this person fined $500. I guess I just have a problem. You could interpret all of the bullet points by the reviewer as being a pretty darn debate. That's all I have.
Any other discussion?
I think I agree with Michael. I really do. And honestly, it could go either way on most of these points. And it depends on the reviewer. Do we trust the reviewer or do we not? And these days, I mean, heck, I get a lot of reports back from AMCs and things with a lot of picky stuff in it. And I tend to lean that way when I read this type of comment. So it's tough to make a decision based on, for me.
Mr. Phillips?
Now that you brought that up, I think we're gonna see this, I don't know if y'all have read the whole thing before by hand. It's highlights sometimes. You're gonna see that throughout this report. And that's something that bothers me a little bit. Some of this stuff seems so subjective. That says something to the effect that we don't have land sales.
Support for site value. Yes.
So, I mean, is that something
But, you know,
that you have to have in a report, or you have to have it in file?
I'm like everyone else that so far that's spoken up. The problem I think sometimes happens is these reviewers at any level feel that they are being, quote, graded, whether or not they're doing their job or not. And they feel if they do not call for it, that somebody's going to accuse them of not doing their job. I reckon I speak from a personal point of view. When I have gotten a copy of a letter from a government agency telling me they're going to put a letter in my file about the fact that I did not do blank and blank, to which I replied, if you look on page 1 and read the report, you'll find it. For which I got a reply back, oh yeah, there it is. And so consequently, this went on for 2 or 3 items like this. And finally, I said, look, let's quit the P contest and get down to the facts, okay? To which we eventually did, and we got everything resolved. But I was told by one of these things, we get graded. If we don't call for things, they don't think we're doing that job. Wait a second. It's not your job. Your job is to make sure the report is factual, okay? Period. You might not agree with it, but that's not your job. Your job is to see whether or not the data is factual or not. Period. You have hired this appraiser for his judgment. Period. The fact that he got page 1 in front of page 2, page 3 in front of page 5 instead of 4, come on, folks. Let's get real. What is the real objective you're trying to obtain here? And that is an accurate appraisal report, not the Mickey Mouse stuff up and down the line. And sometimes I get concerned about this, whether or not this is what's going on tonight. Mr. Johnson?
Thank you, Mr. Chairman. I have to agree with Commissioner Phillips. I've read the entire legal report, And these things are going to surface over and over and over. And they are very gray and nebulous sometimes. And I agree with Chairman Hall. We do work for agencies, and they have reviewers, and they check boxes, and they do feel like they're graded sometimes. And so I feel now I'm not speaking for the commission, I'm speaking for Mark as a commissioner, but my job is to protect the public and make sure we don't have erroneous and fraudulent activities going on. And that's part of my job on this commission, is to weigh those facts. And so in a way, I'm kind of like a state trooper sitting on the side of the road, and I'm watching cars come by and it's 70 miles an hour. And if they're going 71 or 75, are they breaking the law? Yes. Could their tires be bigger? You know, there's a point where you go, are we going to hit every one of these, or are we going to get the guys that are causing trouble? You know, are they running 80 or 90 miles an hour? And so we're going to see this over and over. And the last time I was on the commission, we had these same issues. So these are nothing new. I mean, these have been going on for many, many, many years. And so as I read through these, I have to, in my mind, sort through and go, you know, is that a violation? Yes, it is. But there's not a report that exists in the state of Tennessee that doesn't have a poor sentence structure, a typo, or something that's not 100% accurate in it. Even a demonstration appraisal report will have errors in it. So at that point, I have to look at it and say, is this something that's critical to the public good, and is it a problem that is misleading, fraudulent, and violates the duties of what I'm here to do?
Can I just make one
Sure.
comment?
Go ahead.
I think what we should do then at this point is just, as we go through each item, just try to determine, since this is technically a probable cause type situation, just determine if we have probable cause for each one, to support each one of these recommendations. I mean, if you don't feel like we do have probable cause on each one to support this recommendation, we need to alter the recommendation. If that makes sense.
I think the problem there is, though, we're not looking at the evidence. So how can we make a determination if there's probable cause?
That's why we have expert reviewers doing it, and they're not, you know, I hate to use the phrase, but they're not graded. In fact, all of our experts are told if there's nothing, if there's no violations, just report. They get paid the same whether there's no violations or 100 violations. They get paid exactly the same. We don't grade our expert witnesses, and there's no bonus round for finding more violations or less.
And I certainly don't take what we get from the reviewers and move it around and put it in my own words, because that's just not.
Right.
So it's basically what we get back from the reviewers, what they're seeing.
The legal report is necessarily vanilla. We have to take out specific information so it doesn't have proof. It's not meant to be what would be put on a formal hearing where we put on evidence, say puts on evidence for the commission members to decide. This is just probable cause. If this is true, if the neighborhood section information was not reported accurately, and that seems to be what the complainant, which was a government-sponsored enterprise, was complaining about, that the comparables weren't where the appraiser said they were. That's, that's one of the neighborhood information wasn't accurate. So the reviewer found that was true and cited it.
And these violations, like I said, these conclusions are coming straight from what I received from the reviewer. I certainly don't water anything down, change anything up.
Just take out the specifics, like who, what, where.
To me, this is part of the problem trying to make a decision. It said that explained by misreporting the location of 3 comparable sales, indicating they were closer to the subject property. Excuse me. And then over here under the reviews conclusion, I don't see, well, it just says a neighborhood section, like information, but it didn't really address the issue of how close or how far were the sales that they are saying were are out of the area. I mean, for me, if the review appraiser said, you know, that the person filing the claim is correct, these sales were located 20 miles from this property, not 2 miles as indicated by the appraiser, then that would give us something to work with. But just to say outside of the neighborhood, okay, who defines the boundaries of the neighborhood? I mean, we don't know. So the response is not, you know, adequate for us to make a decision. And
Let's see if we can get you the answer to that question.
great, good.
Would it be helpful, Chairman?
Screen.
Would it be helpful if the reviewers were specifically asked to comment on these items that complainants made? Would that be possible? Or would that be, are we trying to keep this completely within the context of the
Well, we certainly want them to review it for you, we give them a copy of the complaint, so the reviewers see what the complaint, the source of the complaint, where the information that the complainant was alleging. Yes, it would be due diligence to check to see if the allegations were true. If you receive a request from a client to review something, check to see if that is true.
It would be nice if the reviewer might next their address of the complaint within use map.
What? I'm sorry.
It would be nice if the reviewer would specifically nest their response within use map. So when the complainant states that the locations of the 3 cops are wrong, essentially, and they didn't verify the GLA, it would be nice if the reviewer would make that item 1 and then item 2 would say, within use map, you're required to do this here, and you did or did not, or the respondent did or did not. I think that would give this panel a little more,
Yeah, may I add that too?
I'm sorry, do what?
May I add that? I totally agree with what he's saying. I have a complaint here, X, Y, and Z. Here are my issues with this report. The reviewer goes through those, addresses all those issues, and then beyond that scope of work is, furthermore in the report, I found these use path violations and address those. But it's like we see on bullet point number 1, the last sentence, and the boundaries were not accurate. Well, your boundaries, every one of us would have different boundaries.
Have a different boundary.
How, what does that mean? Your boundaries were not accurate. That gives me nothing to go on. You know, it needs to be more specific. First of all, if it's going to be erroneous like this, what does that mean? But going back to what Mr. Green is saying, yes, address all the bullet points that are in the complaint. And then furthermore, if you have something else, like your boundaries were not accurate, well, what and why, and what do you mean by that?
Okay, can I just have one more second? Can I just ask the litigation attorney, Jesse, to just speak on this real
Yes.
quick, and maybe we can get some more clarity?
Good morning, members of the commission. Good morning, everyone. Good morning. I think this is a very interesting discussion. I think everybody has legitimate points, and I think we're all trying to get to the same place. One of the concerns that I think Keeling attempted to point out, and Ms. Avers, was that on probable cause here in the legal report, as everyone knows from the formal hearing process, there's only so much factual detail that she, as commission counsel, can provide you with probable cause, not from the perspective of withholding information from you, but from a due process perspective, since if the respondent does not agree with the consent order, the same respondent's got to come back before you and have a contested evidentiary hearing. So due process requires that the person have a fair hearing and you not have prejudged all of the facts. So if they were to give you all of the detailed facts, there could be a concern raised by a respondent regarding prejudgment. I think that's part of the issue, okay? at what the complainants say. Much of the time, what the complainants say has nothing to do with whether or not there's an alleged violation.
Thank you. Now, we appreciate that very much. I reckon one of the concerns the commission has, and I know I have, I don't want to sign off on saying, yes, what you did is wrong. Only to have them come in here, have an attorney come before us and say, commissioners, here's my map. Here's my subject. Here's my sales. Right here. Here's my neighborhood. How in the world could that reviewer not have known this is what it was? How could you all have grooved like you did with this information? We don't have that information. That's the concern, I believe, that we have, is having adequate information in order to make a decision like this, because I think everybody here is the same opinion. We want to make sure that the public is protected. That's why we're here. That's what we want to do, is make sure they're not getting, quote, bad appraisals. By the same token, I don't want to make judgment based on not knowing the facts. And we're being asked to make a decision based on a subjective decision. And I think that's our concern. Not anybody's right or wrong. I'm not trying to imply that. I just want to make sure we're comfortable with what we're doing.
But it has to be a little subjective in a probable cause recommendation. What we're asking in a legal report is, if this is true, is this the appropriate discipline for that situation? Yeah.
And if you don't think it's enough, then I think at this point, the way we would need to go is you just need to reject this application.
Excuse me, Mr. Walton.
I think every commissioner is going to have to determine, I mean, basically we're being asked to make decisions based on the reviewer's opinion. And each one of us is going to have to make up their own mind as to what arises to the level of probable cause based on complete reliance on the reviewer's recommendations and opinion. So, I mean, until we have an evidentiary hearing, we're not going to get that type of detail. So, you've got to rely on your own conscience and experience as to how much you trust the reviewer to go forward with the council's recommendation on discipline. That's what it just boils down to at this stage, I think.
Could I,
The reviewers don't recommend discipline, they just review the reports for compliance.
Well, yeah, council's recommendation.
do we have a motion on the floor this time?
Yes, we
And
do.
what is that motion?
We have a motion from Mr. Phillips and a second from Ms. Johnson to accept the recommendation.
Okay. Now, just heard the motion again. Any further discussion?
I have to state, in my opinion, looking at the reviewer's evidence and the council's recommendation, I would have to say, in my own opinion, I'm opposed to the discipline that's recommended.
I'm going to withdraw my motion.
I'll withdraw the second as well.
All right. Now, we have no motion on the floor, okay? Now, you want to make a new motion? Go ahead, Jen, you want to make a motion?
In my opinion, I would recommend, again, a letter of warning with no civil penalty.
All right, got a second. Mr. Covington? Has everybody heard the motion and had a lot of discussion? All in favor say aye.
Aye.
Opposed? Motion carries. Thank you, ladies and gentlemen. Next.
Okay. Item number 3, sorry.
Would it be okay if we had a 5-minute break, just
Sure.
because we've been waiting for a really long time?
Send it about 10 minutes.
Keep going.
Tomorrow,
Yes.
2-day meeting.
Call meeting back to order. Just before we adjourn, I believe Mr. Walker is in the process of making a motion, or had made a motion.
It's already done.
Okay, we just need to vote on, is that correct?
No, it's done.
We're up to 23. We're ready for number
Okay,
3.
Keelan?
Okay. Item number 3, 2012007411. This matter is or any permanent heating source to be installed, rather only that it must be adequate for healthful and comfortable living conditions. Respondent states that this is defined as providing and maintaining a temperature of at least 50 degrees Fahrenheit in all living areas and areas containing plumbing systems. Respondent claims that the basement area had an established utility and 3 sides that were below or partially below grade and would be capable of maintaining 50 degrees. Respondent states that reporting the basement as living area is correct and the complaint is not warranted. Reasoning and recommendation. The Commission had previously authorized a consent order with a $500 civil penalty and a 15-hour residential report writing course. After the consent order was sent to Respondent's attorney requested to meet with Executive Director Avers and myself to discuss the order. After meeting with Respondent's attorney on December 13, 2012, Director Avers and I discussed the order and the matters surrounding the order and determined that there were inconsistencies that would warrant closure of the matter with a letter of warning in lieu of the previously authorized consent order and civil penalty. Respondent has been licensed for 12 years with no prior disciplinary action against her. So that we would just be changing this to closure with a letter of warning rather than the civil penalty that was previously authorized.
And the 15-hour residential.
Correct.
We heard the recommendation. Do I hear a motion?
Make a motion.
Motion by Mr. Covenant, second.
I'll second.
Second by Mr. Green. Discussion.
I have a question
Johnson?
for council. This goes back to the previous discussion. This would not be a disciplinary action then, from that standpoint, since it's a letter of warning.
That's correct.
Now, because it has an educational requirement to that, does that automatically push it into a disciplinary action?
Well, the education requirement would be removed along with
Oh,
the
okay, I'm sorry.
No, everything's removed.
everything that
I'm
was
sorry, I
removed.
misunderstood. I thought it was still a letter of
No.
warning with education.
Yeah, just letter of warning, no penalty, no.
I got you. I'm sorry, I just misheard what he
Okay,
said.
Mr. Green?
Is it possible and acceptable and appropriate that you tell us what the inconsistencies were that you all discussed? Or is it not?
And it may be that Nicole might be able to explain it better because it all had to do with the basement area. And I'm not 100% versed on all of that, but she was able to point out in the report things that we didn't think were in the report to begin with. If that makes sense. And she might can explain the basement part
Who
of
was
it.
able to point out, the respondent or?
Well, the respondent had met with the attorney, and the attorney brought everything with her and pointed all these things out to us.
Would you like to discuss this? Please.
Oh, I'm so glad you did ask. That's wonderful.
Can I ask one question before?
Yeah.
It's in reference to this. Does the reviewer have that information that you were able to review and look at? Did that reviewer have that prior to it? So that,
I'm sorry.
did they have that before they made their recommendation?
The reviewer has everything that,
So is it clear, is it fair to say that the reviewer did not even recognize the inconsistencies that Ms. Avers did?
The reviewer receives a copy of the initial complaint, the appraisal, and the response that the respondent makes to the complaint. Usually that's the appraisal, the work file, and whatever letter they submit responding to the complaint. When the consent order was authorized, the respondent engaged an attorney, and the attorney was able to better articulate than the respondent did. The information was communicated in the appraisal, but it was communicated inconsistently in the report in different areas, which is why a letter of warning is warranted.
I think it was more of a reporting issue than it was a substantive issue within the report itself.
Maybe I misheard it, but I thought you saw the inconsistencies and where they was, and the reviewer didn't.
Mr. Johnson, I appreciate this line that you're going on. However, let's go ahead and vote on this recommendation at this point in time. Then I think what you're talking about would be a separate issue we need to address. And I'll clarify that if we vote on this matter.
Well, it was in reference to that
I
motion,
know that,
so.
but I realize that. But it goes, I think it goes
Might
further.
be part of a broader issue.
It is, correct. That's, in other words, what we're talking about, my opinion, Mark, is not just this one case. It goes to what we've spent 20 minutes
I
on
understand.
previously.
Okay. I'll
And
agree.
so we get back into this again, we're going to spend another 20 minutes here talking about the same thing we talked about 20 minutes before. So let's just go ahead and get this put to bed, then we can open up another can. Mr. Walker?
Mr. Chairman, I would disagree. I think we need to have discussion before we can vote on this. And to me, there's an issue with this case that, this is for me where kind of the rubber meets the road. The last case I felt like was very subjective. This case, it sounds like there is more empirical evidence of inadequate appraisal reporting and technique. And from what I'm reading in the complaint and the response, the commission thought that there was evidence enough to proceed with a civil penalty before. And when I haven't read anything in this complaint that really changes that substantially. To me, when you're appraising a property and it's got a finished basement, non-finished basement, if there's no heat source and this property only maintains a temperature of 50 degrees, how many people are going to stay in a room that's 50 degrees in the wintertime? I think that there's a value issue. There's an issue there that would impact value for that living space. Whereas, like I say, I think the other one was kind of subjective. I think there's empirical evidence here that there may be just cause for a civil penalty here, because it would impact value, and that's the bottom line of what we do as appraisers.
This point, did you have a question? Yes, sir. Sorry. Excuse me. Anybody else have any questions, comments?
Yeah, Mr. Walton's train of thought. Yes, it would impact value, and that's what we do every day. But per guidelines, I think, if it maintains X temperature, and with these things in place, 3 sides of the house being below grade and whatever else may be in the report we don't know about, and FHA says, or whatever guidelines say, it needs to maintain a specific temperature of 50 degrees, whether we agree that that's adequate and we go down there and hang out or not. If that's in the report somewhere, as Ms. Avers obviously found or indicated somewhere, then I'm not so sure that, I think the appraiser probably did his job, but maybe didn't outline it in the way that we would normally do it. But the reader of the report, if they read it correctly and thoroughly, would have found it somewhere in this addendum here or over here, but not where we might typically address it. So I kind of agree and disagree. Well, I don't have all the data either.
My interpretation of reading this is this, and as appraisers, I think it's our job to not just go by the letter of the law, but interpret from value from the standpoint of the market. And as a consumer, if I walk in and the basement looks terrific, but there's no heat source down there, I'm going to pay less for that house than if there was heat, and I could use that space year-round. And it sounds to me, I could be wrong, but it sounds to me, I'm reading between the lines here, that was the case with this, and I think that would have an impact on value. So I say, to me, there's meat here, whereas the other one, I'm not so sure that there was. There was, and that's just my opinion, and that's my line of thinking.
Okay, Mr. Green?
I'll weigh in real quick. I sense 2 sides to this, and I think I'm getting your comments from sort of a civil homeowner perspective, and I look at this report and I go, hey bud, you didn't tell me there was no heat here. You said it was finished, and you didn't tell me there was no heat. Yeah, you probably meant use map, and you probably reported it somewhere, but I don't appreciate it from a homeowner standpoint.
And I think that's the end goal, kind of what we do is putting in shoe leather
Be careful,
a
though,
practical
because
approach
we've
to
heard
value.
we've heard from our legal counsel and we've heard from our executive director, and it doesn't sound to me like they think if we go to a formal hearing that that we would necessarily prevail with that harder, firmer education advice. That's what I'm getting.
Okay. Does
Just
anybody
to
else have
clarify,
any other?
Mr. Hall,
Please.
I don't do an independent review. Just so that's, on any of these matters, I don't do an independent review, so I'm not a reviewer on any of these. If the respondents request an informal conference, legal counsel and I will meet with them. In this situation, the respondent engaged an attorney, the attorney came and the respondent did not. It was the attorney that came to the informal conference and discussed it. The respondent did not. I don't feel like the respondent complied with use path. This is my opinion. I agree with Mr. Walton there. I believe there would be grounds to support that they violated use path, specifically that they did not meet the assignment conditions pertaining to FHA reporting on living area. I don't think that you can call anything in Tennessee living area if it doesn't have a heat source. I think that we made that abundantly clear to respondents' counsel that it gets cold in Tennessee basements. No matter what part of Tennessee you live in, it gets cold in Tennessee basements. It's not Florida, it's not Bahamas. It's, even if you have an open air basement area, it will get cold, as it did last night, somewhere in Tennessee. So I don't want to give the impression that I'm saying that the respondent did not violate use pattern. We are requesting leniency because the respondent has not been disciplined in a 14-year history, and the letter of warning would be a non-disciplinary action that, although it's not discipline, if they were to do it again, it can be considered aggravating in the next matter, so they can be disciplined additionally. Do I think it's worth the commission's effort to go all the way to a formal hearing to discipline somebody for reporting the venting? I don't know. So that's all I'm going to say about that. Without
Mr. Johnston?
Mr. Chairman, I call for the previous question.
Got a call for the question. All those in favor say aye. Opposed, like sign.
I'm opposed.
Only got one vote out of this. Let's have a show of hands. All in favor? Green.
Can we clarify what the motion was first?
What's-
Just
Motion
make-
was to accept the recommendation.
Okay.
Okay.
Well, the call for the question was to cease debate and vote on the
Exactly.
question.
Exactly. The motion was to accept it. Mr. Green?
Nay.
Okay. Mr. Johnstone?
Yes.
Phillips?
Yes.
Walker?
Nay.
Yes.
Aye.
Yes.
Ayes have it, motion carried. Next one.
I remember.
Now, before we get started, Mr. Johnstone, I had indicated that where you were going, I thought was another avenue. And I do, because the last one we had was really, and Mr. Walter brought up the same thing again, is whether or not we are going to accept what the reviewers are telling us.
Well, I
And
wasn't
so-
going down that rabbit hole, but I
And
can
so
see how.
consequently, that's why it sounds like we're heading again on this thing. And I think this is a real question that we're going to have to, at some point in time, address, is whether or not we're going to accept the recommendations by the review appraisers, and are we going to accept the recommendations by Duke? Because if we're not going to accept them, then we have got to resolve that issue.
Right, and just for a point of clarification, the reviewers themselves are not making any kind of legal recommendation. All they are doing is giving us the conclusions. on the alleged violations. It's me that comes up with the actual legal recommendations. So just to clear that up, the reviewers are not making any kind of recommendations for disciplinary action or anything like that.
Okay. Go ahead.
Okay, item number 4, 2012-017-491. This complaint was filed by a consumer and alleged that respondent performed an appraisal report containing multiple inaccuracies, including items such as incorrect square footage and incorrect number of full and half baths. The complainant also alleged that respondent used comparable cells that were not comparable to the subject property. The respondent sent a response stating that the subject property had unfinished area on the second level and the basement level, which were not included in the GLA of property, and the first floor has 2-story ceiling area, which is noted in the report. This was the only response provided by respondent. The reviewer conclusions are as follows. The appraisal report fails to provide adequate reconciliation for the sales comparison approach and the site value opinion. The appraisal report fails to summarize and support the following opinions and conclusions: opinion of site value, opinion of value in the sales comparison approach, opinion of value in the cost approach relating to external obsolescence. The appraisal report fails to summarize the opinion of highest and best use, both as improved and as vacant. The appraisal incorrectly describes the physical characteristics of the subject by providing an inaccurate site description. The appraisal report has sufficient cumulative violations to support a lack of sufficient care to avoid errors that may affect the assignment results. The appraisal report has sufficient violations so as to result in insufficient information for intended users to understand. Failure to understand and apply proper appraisal techniques with regard to economic obsolescence in the cost approach represents a lack of confidence in applying depreciation in the cost approach. The recommendation is the reviewer found that the issue of inaccurate square footage as alleged by complainant should be dismissed. The complainant has provided no additional support for the alleged inaccuracies regarding bath count. The reviewer found no supportable inaccuracies to support the complainant's allegation. Comparable cells are limited for this assignment, and the appraiser used the best available as of the date of the appraisal. However, the reviewer did find multiple violations of use path within the appraisal report so as to warrant disciplinary action against the respondent. As such, counsel recommends a consent order authorizing a civil penalty in the amount of $500 to be satisfied within 30 days of execution of this consent order, and a 15-hour residential appraiser site valuation and cost approach course, and a 15-hour residential report writing and case studies course to be satisfied within 180 days of execution of the consent order. These terms are to be settled by consent order or formal hearing. Civil penalty should serve as a sufficient economic deterrent, while the corrective education should assist the respondent in becoming a more effective appraiser, thereby protecting the interests of the public.
Y'all have heard the recommendation. Do I hear a motion?
Move to accept.
Have a motion, I hear a second. Motion by Dr. Barella, second by Mr. Green. Discussion.
I'll be quick. I think this write-up is very helpful. The way this is structured helps me greatly. I'm wondering if in the future they could all resemble this. And when it says, as such, counsel recommends, it'd be nice. Put the reviewer stuff in one color and put counsel stuff in another color.
Okay.
That'd be really helpful.
Thank you.
Any other comments?
Just one more time, I think that the substantive empirical inadequacies identified by the complainant weren't really supported here, and a lot of it was subjective development and summary of approaches and that sort of thing. I think that's a report writing issue. I don't think doesn't sound like there was necessarily anything in here that would impact value, which is, again, the bottom line of what we do. I just have a problem taking money out of appraisers' pockets. I think a letter of warning, something corrective instead of punitive, would be my approach here. Right, I mean, I'm just having discussion.
This is discussion.
Make a motion that we amend the original motion.
You have to vote on the matter.
No, you vote on amendment. If there's an amendment, it takes precedence over the original motion. Vote on the amendment first.
Yeah.
Can someone restate the amendment?
My motion was to amend the recommendation here, the action we're going to take, and remove the civil penalty. I don't necessarily have a problem with requiring a report writing class. I think that's what's needed here. But
To remove the civil penalty.
So do you agree with the two classes that we had listed on here?
Letterman.
I know you said remove the civil penalty, but they're also two separate,
Site evaluation.
separate continuing education classes.
You got two courses you could.
I think report writing is in order, but again, the reviewer doesn't state that there was an actual problem with the site value. If I'm reading this correctly, it sounds more like that they just didn't state how they developed the site value.
There's violations noted for the appraiser, the very last bullet point. Failed to understand and apply appraisal techniques regarding external obsolescence and the cost approach. And then analyze and apply the highest and best use as approved in Fagan. All of that external obsolescence stuff goes back to the cost approach. There's major issues reported in that section of the report.
First bullet point too, depending on how you interpret that, somebody's ready to try stuff, but adequate reconciliation for the sales comparison approach and the site value. So maybe there was problems in the sales comparison and how they arrived at their site value.
Okay,
Could I have a point of clarification on the amendment?
go ahead.
What is the amendment?
The amendment is to remove the civil penalty. Basically, I understand that pretty as well.
Correct.
Another
Courses.
point of,
We
point
can
of,
keep the courses and instate a letter of instruction, included in the letter of instruction.
It would probably still be a consent order, just authorizing
Okay.
the continuing education classes,
Okay.
just taking out the penalty.
question, is a consent order authorizing classes is disciplinary action, just without a civil penalty. A letter of instruction or caution or warning would then not be a disciplinary action.
Letters of warning, caution, and instruction are not disciplinary, we
So
cannot
we're-
enforce
So we're
classes.
so this amendment would still be a disciplinary action, just no civil penalty.
Right. Right, and I don't think we have a second on the amendment.
We do
need
not.
one?
We do not.
I'll second that.
Got a second? Got any further discussion on that? Voting on the amendment to remove the $500 civil penalty. All in favor say aye. Aye. Opposed? Carries. No. One opposed. All right, back to the main motion now. All those in favor say aye. Aye. Opposed, like sign. Motion carries. Proceed.
I'm sorry, was that the vote on the, I got confused. I
Yeah, we had a vote on the amendment. Mr. Green opposed. Everybody else voted for it. Then we went to the main motion, and that one was carried.
Could you, all right, so the main motion was Barilla and Green, and that was a unanimous vote,
Well, as amended,
as amended.
correct. And the amendment is we remove the civil penalty.
I don't think it was stated that way when you guys voted on the original motion, so we want to go back and do it again.
I'm confused. I don't know, I'm typing up the minutes, and I apologize, I've never done it that
I think
way.
the amendment was voted on, and then you went back to the previous
Correct.
motion and.
As amended, as
Yeah,
amended.
it would be inherent in that it was as amended since you voted on it.
Correct.
You could have been stated as.
It was a motion as amended.
So would I still count Mr. Green as objecting to his own
No,
second?
no. He objected on the amendment, not the main motion, on the amendment.
So what is the effect?
The fact is, the effect, the way I understand it, is we voted to recommend everything that Keeling had in here except the $500 civil penalty.
Okay, figured out.
That was the intent of the various motions that were made and passed. Okay? Mr. Johnson?
Mr. Chairman, as a point of clarification on the amendment, the original motion was amended by Mr. Walton, seconded by Mr. Covington. So when we voted on that, Commissioner Green, known him for 30 years, Commissioner Green voted no on that, and but it passed. So then, once the amendment was either voted up or down, if it had not passed, the motion would have been just like it was recommended from council. But since the amendment did pass, and it was amended to remove that $500 civil penalty, at that time, the vote from Mr. Green was affirmative to do that. So just because you second doesn't necessarily mean you can vote against it. You can second something, but then you don't have to vote for it.
All right, I'm just going to put down that the motion passed at the end.
The amended motion
Purpose
passed.
of the minutes.
We'll let you keep you on your time.
The motion as amended passed.
Motion as amended passed.
Correct.
I've got that, thank you.
Good. Okay, go ahead.
Okay, item number 5 has two separate matters, 2012-018-651 and 2012-015-211. And this first portion relates to item 2012-018-651. Complaint was filed by a consumer, potential homeowner, and alleged that respondent delayed delivering the appraisal report. In addition, the complaint alleged that the report contained numerous misspellings, incorrect information, and neglected to mention that the property was lakefront property. The complaint also alleged that the commercial sale properties utilized in the report are not in the same property area. The respondent states in his response that in regard to lakefront property, this property is land that is owned by a separate entity, and that this entity's property lies between the subject property and the lake, according to the property assessor's records. Also, respondent states that in the contract it stated that the seller will not clear out brush that leads to lakefront, as that property belongs to a separate entity and the homeowner needs a permit from the entity to do so. Respondent states that the property does not go to the lake. Respondent denies that the grammar used in the report was incorrect, as was stated in the complaint. According to MLS, this property did not close and expired. Respondent states that neither the seller nor the seller's agent nor the buyer's agent questioned the appraisal. Only the buyer questioned the appraisal because she didn't get what she wanted. Respondent states that the complaint is without merit and should be dismissed. The reviewer conclusions are as follows. There is no opinion of reasonable exposure time stated in the appraisal report. The report indicates an exposure time but provides no explanation or support for this conclusion. Thus, it is not reasonable as described in NewsPath. The appraisal report failed to summarize and support the following opinions and conclusions. Opinion of site value, opinion of adjustments in the sales comparison approach for site differences, and the analysis of the sales contract relating to personal property. The appraisal report failed to summarize the opinion of highest and best use, both as improved and as vacant. The appraisal report failed to state whether prior services have been performed on the subject property within the previous 3 years and the report certification. The appraisal report has sufficient cumulative violations to support lack of due diligence, resulting in appraisal services having been performed in a careless and negligent manner, resulting in conclusions that are not credible. The appraisal report failed to summarize information sufficient to identify the physical characteristics of the subject property. The appraisal report failed to identify the characteristics of the property that are relevant, such as the lake amenity. The appraisal report failed to identify any known easements, restrictions, etc. regarding lake access. The work file submitted to the review appraiser did not contain any data to support the site value opinion or site adjustments made in the sales comparison approach or a true copy of the original appraisal report submitted to the client. And then the second section references item number 2012-015-211. This complaint was filed by a consumer homeowner and alleged that the respondent communicated an appraisal with numerous errors which caused the property to be undervalued. Complainant alleged that the square footage of the property was reported incorrectly and the respondent used comparable cells that were not consistent with the subject property area. Respondent sent a response stating that this complaint was without merit. The appraisal in question was completed for a mortgage finance transaction and not for personal use or tax purposes. On the issue of incorrect square footage, respondent states that in complainant's complaint to the lender, the square footage was taken from the MLS 2001 when it was listed. Tax records and the MLS do not agree about the square footage. The assessor of property rounds the measurements on the improvements and does not use inches. This can make a house larger or smaller than the true size. Respondent also states there are no comparable sales in complainant's subdivision and that the comparable sales complainant provided do not meet the criteria for respondent's search. Respondent states these comparable sales are all within 90 days and all within 250 square feet of the subject. The reviewer conclusions are: the appraisal report failed to summarize and support the following opinions and conclusions: opinion of site value, opinion of adjustments in the sales comparison approach for site differences in garage, and the absence of adjustments for sales concessions. The appraisal report failed to summarize the opinion of highest and best use, both as improved and as vacant. The appraisal report failed to state whether prior services had been performed on the subject property within the previous 3 years in the report certification. The report has sufficient violations to support lack of due diligence, resulting in appraisal services having been performed in a careless and negligent manner, resulting in conclusions that are not credible. The work file submitted to the review appraiser did not contain any data to support the adjustments for site and garage made in the sales comparison approach. The report certification did not contain a statement regarding any previous services performed by the appraiser with regard to the subject property in the previous 36 months. The appraiser did not disclose all seller concessions involved in the sale of the comparable sales. The appraiser committed substantial errors of omission that significantly affected the appraisal. Recommendation is the reviewer found that the appraisal report contained multiple violations of use path as stated above, along with misspelled words, poor grammar, and poor sentence structure. Carelessness is so prevalent that the overall credibility of the appraisals are questionable. As such, counsel recommends the authorization of a civil penalty in the amount of $1,000 to be satisfied within 30 days of execution of the consent order, and a 15-hour residential report writing and case studies course, and a 15-hour advanced residential application and case studies course to be completed within 180 days of execution of the consent order. These terms are to be settled by consent order or formal hearing. Civil penalty should serve as a sufficient economic deterrent, while the corrective education should assist the respondent in becoming a more effective appraiser, thereby protecting the interests of the public.
Okay, we heard the recommendation. Do I hear a motion?
I'll move to accept.
And a motion, Mr. Green, accept. Do I hear a second?
Second.
Second by Mr. Walton. Either one at the same time.
Okay. Got it. Mr. Walton.
Discussion?
I wonder if the legal report should be amended. You have disciplinary history and you have the 2 cases showing as pending.
Those are just the 2 that are,
We don't normally put that.
okay. I can
The other
knock it
2
out.
we're discussing right now, is that correct?
Correct. Normally that's a none.
Okay. That's my fault, sorry.
No, I don't mean to pick on you. I just don't want anything to come up.
I don't mind being picked
Yeah,
on.
right, yeah. We want it to be clean and tight, so.
So yeah, just to clarify, those 2 numbers that are there are actually the ones that we just discussed, so technically that should say.
Any discussion on this? Hearing none, all in favor say aye.
Aye.
Opposed, like sign, motion carries.
Item number 6, 2011030681. This is another matter that's being represented from the December 2012 Commission meeting. This complaint was filed by a concerned citizen and alleged that respondent failed to verify comparable sale data, made adjustments inappropriately or negligently, and failed to define the scope of work conducted in the appraisal report. The complainant alleged the errors in the report affected the value opinion in the appraisal for eminent domain purposes of a land acquisition of 12 planned vacant lots. The respondent defended his comparable data selections and adjustments applied. He indicated that the value opinion was well supported and no violation of use path occurred. The Commission determined at the December 2012 board meeting that it needed more information before authorizing any form of discipline in this matter. The Commission requested information regarding whether the subject property was a recorded plat, as well as who the condemning agency was in the matter. After re-review of the file, it was determined that the subject property consisted of an over 31-acre lot that was divided into 12 planned lots as an unrecorded platted subdivision. Tennessee Department of Transportation is the condemning agency in this case. The review conclusions were as follows. The reporting option was not clearly presented in the report. The report does not utilize the proper definition of market value for the type of assignment. The report does not provide adequate identifying information on the subject lots. The sales comparison approach is unsupported and not adequately completed, and the reconciliation is not appropriately completed. The reviewer found that overall it does not appear that the appraisal report has been conveyed in an appropriate manner. In addition, the reviewer found that the report does not contain sufficient information to enable the intended users to understand and rely on the conclusions presented. The respondent has been a certified general appraiser for over 17 years with no prior disciplinary history. Thus, council recommends the authorization of a civil penalty in the amount of $500 to be settled within 30 days of execution of the consent order, and a 30-hour course on general appraiser report writing and case studies to be completed within 180 days of execution of the consent order. These terms are to be settled by consent order or formal hearing, and the civil penalty should serve as a sufficient economic deterrent, while the corrective education should assist the respondent in becoming a more effective appraiser and thereby protecting the interests of the public.
You've heard the recommendation. I hear a motion. Do I hear a motion?
I'll make a motion to accept.
Got a motion to accept from Mr. Phillips. Do I hear a second?
I second it.
Second by Ms. Point. Discussion. Johnstone?
Sorry. The course requirement there, this is a TDOT eminent domain case. A general report writing and case studies is not really going to be of any benefit in that situation. You want an RIWA type course or something of that nature. The condemning authority, it says the conclusions were not sufficient for the intended users to understand. The intended user would have been TDOT. They have a very intensive review process that they look at, and it's back and forth. We've got a 17-year no prior disciplinary history, and you've got an unrecorded plat. I see these all the time in eminent domain work where I do. You know, any property owner can pull a plat out and go, I'm going to put this in here. It's not recorded. You don't know the date it was stamped. That's just a way they use to work the system to get more money. Complaint was filed by a concerned citizen. Not that we don't have to protect the public, but this individual is really not even, doesn't really have a dog in the hunt aside from they're the public, which we do need to protect them. Reporting option, you know, definition of market value. There is a definition that's, you know, that's used for PDOT. It's in the forms, so it may not be the market value definition that one might see in a USPAP type report or for a lender. So I just see so many inconsistencies that I cannot agree with this motion as it is. I would like to amend it to be a letter of warning with no penalty.
I second that motion.
Got a motion and a second to amend this recommendation to
Letter of warning.
letter of warning.
Just
If I may
for
make-
point of clarification, this was reviewed by someone who does have expertise in this area. Those were the
Yeah.
areas it was not just a,
I still keep my motion
Yeah.
as is.
If I may make an
Amendments, Ken.
observation though about this, Mr. Johnstone, the Department of Transportation, while they do have a review in place, it would appear that this report was not made for the Tennessee Department of Transportation. Could be mistaken with that.
Says the condemning, says
The
the last
condemning
sentence.
authority was the Tennessee, but it doesn't say that they were the ones who filed the complaint.
It
And
was-
so therefore, it could have been a report done by an individual, and the Tennessee Department did not do the review on this report, so the report, we do not know whether or not it would have met their standards.
That is true. But it, I mean,
So
it
that's only observation I'm making.
right. Was it prepared for the Tennessee Department of Transportation? Can we ask that? Yeah.
I think the concern was whether or not this was a state agency or federal agency. Because in the state agency is, you cannot introduce unrecorded plats. You can't do it. And if this appraiser did introduce an unreported plat, then he was in violation of state law, the appraisal principles or standards, which he probably was also.
Say again.
I said that if he introduced an unreported plat,
The homeowner or the property?
whomever,
We don't-
the appraiser,
I don't believe
I
the
didn't see
appraiser
that
did.
as to what
I don't know
happened.
whether he did it or not, but if you may base his appraisal on an unrecorded plat, then that would have been incorrect.
I didn't infer it, I inferred it as,
That's what I don't know.
I'm getting right the opposite. The homeowner said, here's my plat. He didn't appraise it that way.
Okay.
That's just the way I understood it.
I don't know.
I guess I'm in reviewing the reviewer's comments. The only bullet point that I think has strength, maybe, is the second to the last one. I mean, that's the kind of meaty review that I think is done. You know, the other things to me are a matter of degree, but that bullet point to me is what ought to be addressed in the punishment. That's my personal opinion.
Which they did really.
It says, it's the second to the last one. It says the sales comparison approach is unsupported and not adequately complete. And that's pretty cut and dry.
Another problem we might have is we don't normally make any rulings on any pending cases, whether any condemning authority is involved. You know, if there is a case and it's pending, then we do not make a decision until after the fact, because we don't want either side to be able to say, hey, the commission said X. So that's,
Actually, we don't wait.
you change that?
We review the matters for compliance with use path,
Period.
period.
I know at one time we would not review them if they were subject to litigation.
The only time we wait for litigation is if that is the single allegation. It's like the allegation is the respondent has been charged with robbing a bank. He hasn't been convicted. So we wait until he was convicted of robbing a bank, until we discipline
I know in the
him.
past
And,
before-
we don't wait
Right.
for
Well, I know in
litigation.
the past, we had kind of not made any rulings simply because we did not want to be drugged into court as being on one side or the other, regardless of which side it might be. You know.
We don't use that as a sole basis for making a determination. It helps us run afoul of policy statements. The ASC policy statements would run us over a year, because what litigation, that would be done in less than a year.
It can go for a long time.
Right,
You know, I've got one.
and so we're reviewing them for use cap compliance, and many times the litigation has nothing to do with use cap compliance. They may be pursuing other aspects of that litigation, and it has nothing to do with.
I agree with Mr. Chairman there that certainly opposing counsel in a jury trial can bring that up, and whether it's and really paint a gruesome picture, whether it's merited or not. That's actually a good technique. I'm glad you brought it up. I might suggest that to someone. Just
And we've
kidding.
had respondents come in and say, hey, I don't want to sign a consent order because if I do, it'll be used against me.
Right.
Very well. And there have even been isolated incidences where we signed essentially no contest, like I'm not admitting to anything, but I'll sign a disciplinary order. That's only happened once that I can recall it, but it has happened.
Well, my concern
But waiting
is-
for litigation is no, it's not.
My concern is if we are not careful, we're going to start having attorneys filing out of the yazoo with us to make these decisions so they can call us into court for their side, regardless one way or the other. I just don't want us to become pawns in the legal system.
Well, you wouldn't be. I have been.
So
But
I
thank
don't
you.
want you to either. I don't think that's their responsibility, is to be called into court for one side or the other. I really don't.
It's nature of the animal. We just can't wait for it. We don't get so many complaints of this nature that I would spend a lot of time worrying about it.
I agree. I hope
Just
so.
on the merits is the grounds for, is these reporting issues grounds for disciplining this appraiser? That's all we're asking for probable cause.
And also, the information regarding who the appraisal report was done for is actually on a disc, so she's checking that right now. So if you guys want to defer this, we can keep moving and come back if it's that important.
I'd move that we defer this until later in the agenda, until we get that information about the intended user.
Do we have a second to that? Got a second? Kurt? We second it? Did you, Kurt?
I'm the one who made the motion.
Okay.
Original motion.
Okay.
I move to defer to later in the meeting, once we can get information on the intended user and client.
Do we need?
Okay. If we move to defer, I'll take the rest of the motion.
That's right.
Okay. We have a motion to defer this until later. All in favor, say aye. Opposed, like sign. Okay, go ahead.
Okay, item number 7, 2012007121. This complaint was filed by a consumer homeowner who was in the process of refinancing his home and alleged that respondent undervalued residential property. The respondent states that the opinion stated in his appraisal report is fair and accurate, and that he collected all the available information on the subject property through the normal and typical appraisal channels. The respondent states that the opinion of value is not determined by a preset percentage of decrease or increase, rather the opinion is developed by research parameters and the market activity, data, and information available by typical appraisers' research for market in the local appraisal practice. The respondent states that he has completed the assignment under the requirements of USPAP and Tennessee law. The reviewer conclusion was that the adequate reasoning or support for adjustments in the sales comparison approach was not provided in the appraisal report. The reviewer found that the report contains sufficient information to enable the client and intended users to understand it for the most part. However, the report does not provide adequate reasoning or support for the adjustments made in the sales comparison approach. The only comments found in the report were all adjustments made for comparable dissimilarities are market-derived according to MNMA adjustments. No, guidelines, sorry. Comparable adjustments are made as warranted when research deems verifiable. Adjustments were derived from the estimated market reaction to the differences of the subject as compared to the available comparables. According to the report, the comparable cells were older than the subject, and the comparable cells were located on a golf course, while the subject property was not. While it is recognized that these adjustments may be appropriate, there are no comments or information found in the report or work file that provides any analysis, opinions, or conclusions for the adjustments utilized. However, the reviewer did note that overall the appraiser does appear to understand methods and techniques in completing the approach to value. The respondent has been licensed as a certified residential appraiser for almost 23 years with no past disciplinary action against him. As such, counsel recommends closure of this matter with a letter of warning regarding the lack of analysis or support for the adjustments to value made in this appraisal report.
Make the motion to accept.
Got a motion from Mr. Covington to accept. Got a second?
Second.
Got a second, Dr. Corrala. Discussion? Discussion?
Call the motion.
Hearing none. All in favor say aye.
Aye.
Opposed, like sign.
Okay, item number 8 is 2012013631. This complaint was filed by a consumer and alleged that respondent undervalued a residential property. The respondent sent a lengthy response stating that the appraisal was completed with the 3 closest and best available comparable cells found in the local MLS data system inside the rural community. The search revealed only 3 comparable cells. Due to the limited comparable cells, the search was expanded to include the entire county. In reconciliation, the 3 original comparable cells were determined the best available inside the county for the appraisal assignment. The final opinion of market value was determined by the adjusted sales price from all 3 comparable cells. Respondent states that she did the best job possible with what comparable cells were available to work with in the subject area. The reviewer conclusions are the appraisal report contained no lot sales, site development, or reconciliation to support the site value. The appraisal report did not contain disclosure of prior service. Respondent's license number was not listed on the reports per the TCA requirement, and I think I skipped one. The work file material dated after the date of the appraisal report. Reasoning and recommendation are, despite several listed violations, the reviewer found that the appraisal report submitted by respondent to be complete and credible as a whole. Respondent has been licensed as a certified residential appraisal for almost 4 years. No prior disciplinary action against. As such, council recommends this matter be closed with a letter of warning regarding the violations found by the reviewer listed above.
Heard the recommendations, I hear a motion.
Make a motion.
accept.
Motion to accept, Mr. Wolfen, second by Ms. Johnson. Discussion. Hearing none, all in favor say aye.
Aye.
Opposed, like sign. Next.
Item number 9, 2012-015561. This complaint was filed by a consumer and alleged that respondent understated the square footage, which caused an undervaluing of the subject property by using the unfinished square footage instead of the finished square footage. Complainant alleged this cost him more than $31,000. The respondent stated in his response letter that the complaint is without merit. The respondent noted that the appraisal report submitted had the correct square footage on the sketch page. The numbers for finished and unfinished square footages were transposed. The result of the transposition of the numbers would not qualify as gross negligence as stated in the complaint. The resulting error would only have had a 0.8% difference in the adjusted sales price of the comparable sales. In addition, the respondent stated that the appraised value is further supported by the sales price of the comparable sales. The value opinion within the report would not have been changed had the numbers not been transposed. Respondent stated that the client was aware of the transposed figures within the report as well. The appraiser's opinion of value remained the same, and the client did not request that this transposition be corrected. Respondent stated that throughout the appraisal process, he conducted business in a manner consistent with the scope of work, requirements of the lender, and intended use of the appraiser. The reviewer conclusions are the neighborhood section information is inconsistent with the rest of the report, and the boundaries are inaccurate. The description of improvement section contains an inaccurate statement. The section for describing the condition of the property contains the statement, typical floor plans in this area either have 2 large bedrooms on the main level or 3 smaller ones. This floor plan would be considered typical. The statement is not accurate as 2 bedrooms on the main level are not typical in this subdivision or neighborhood. The appraisal report is missing comparable sale information, does not agree with MLS records. The appraisal report contained no lot sales or site value development or reconciliation for the site value. The recommendation is the reviewer found the report to be lacking in completeness and credibility due to the many report errors on the part of respondent. Respondent has been licensed as a certified residential appraiser for almost 12 years with no prior disciplinary action against him. As such, council recommends the authorization of a civil penalty in the amount of $500 to be satisfied within 30 days of execution of the consent order, and a 15-hour residential report writing and case studies course to be completed within 180 days of execution of the consent order. Terms are to be satisfied by consent order or formal hearing. Civil penalty should serve as a sufficient economic deterrent, while the Code of Education should assist the respondent in becoming a more effective appraiser, thereby protecting the interests of the public.
Heard the recommendation, do I hear a motion?
Move to accept.
Second.
Got a motion on Mr. Green, second by Mr. Phillips. Discussion?
I have a question.
Yes, sir.
Sounds like most of these, bullet point number 2, I guess, description of improvement section containing inaccurate statements about the 2-bedroom versus the 3. Some of these things in here sound like information used in a previous report that I just forgot to go back in and, I didn't review my own work thoroughly enough. I don't know if, I think maybe some class hours, may be appropriate here, but I'm kind of the opinion, unless maybe some more discussion is had, that, we take away the civil penalty and make this appraiser take some classes, slow down, produce a more credible report, support the opinions, what have you. I just think some of this stuff was left in from a previous appraisal, actually. And I think we may have all done that before. Has some comments in there that are consistent with the rest of the report. There's a couple of bullet points that point to that. So, point number 1 and 2.
discussion on this matter?
I'd agree, but I think there's enough negligence here with him transposing the square footages, having erroneous comments in there. I think that this one, there's enough meat there that we need to employ discipline. I don't think $500 is too harsh. I would agree with the recommendations on this one.
Mr. Green?
I used the word egregious.
I'm sorry.
I would say the errors are egregious and need to be addressed. They're not real great.
Okay. Any other comments? Hearing none, all in favor of the motion, say aye.
Aye.
Opposed, like sign. Motion carries.
Item number 10 is 2012-012-601. This matter is being represented from the December 2012 Commission meeting. This complaint was filed by a consumer and alleged that respondent undervalued a residential property by communicating a misleading appraisal report, misreporting the square footage, and used inappropriate comparable sales data. The respondent provided a lengthy response stating that the lowest level of the home is below grade and meets the definition of a basement by both local and national standards. Therefore, it is characterized as a basement and not a 2.5-story home as suggested by the owner. The respondent states that, according to Fannie Mae guidelines, the appraiser should report the basement or other partially below grade areas separately and make appropriate adjustments for them. The respondent states that he did measure the home properly and the calculations have been checked and are correct. The respondent also states that the subject property is part of an overnight rental program and this information was reported in the appraisal report as required. The respondent indicated that he analyzed the most current, reliable, indicative data available and adhered to all necessary and applicable standards to prepare the appraisal of the subject property. The reviewer concluded that the neighborhood section of the appraisal report lacks sufficient information about the market area. The neighborhood is a high-traffic, tourist-driven resort area. This was not reported by the respondent. It was also found that the improvement section contains some conflicting statements. The report has the subject's attic marked none and finished, and the foundation marked crawl space and full basement with no explanation given. The sales comparison approach had some inconsistent information and did not discuss any reconciliation that derived the indicative value. Prior sales of the subject property were not properly or accurately disclosed on the form. There were no lot sale documents or reconciliation in the report to support for the site value. The income approach was conflicting as to whether it was developed or not for a rental income-producing property. Indications of several errors or copying of another report caused several confusing report issues. Data reference material dated after the date of report indicated the copies of data were added to the work file. Such conclusions constitute multiple violations of USPAP Standards 1, 2, and the ethics rule. Reasoning and recommendation are: the commission had previously authorized a consent order with a $500 civil penalty and a 30-hour residential sales comparison and income approaches course. After the consent order was sent to respondent requested to meet with Executive Director Appraiser and myself to discuss the order. All of the relevant information was contained within the appraisal report, including pictures of both crawl space and basement finished space area, but checking both boxes on the URA or AR form without explanation caused the report to be confusing. Many of the reporting errors were from cloning data from prior appraisal reports and not revising. The respondent was able during the informal conference to show proper development of the approaches to value and that work file records were appropriately maintained from the time of the original appraisal date. After meeting with respondent on January 4, 2012, Director Avers and I discussed the order and the matters surrounding the order and determined there were inconsistencies that warrant closure of the matter with a letter of warning in lieu of previously authorized consent order and civil penalty. Respondent has been licensed for almost 16 years with no prior disciplinary action. The major issues with the appraisal report deal with reporting issues rather than substantive issues. The letter of warning would address the reporting issues with regard to Standard Rule 2.1b, which states that each written or oral real property appraisal report must contain sufficient information to enable the users of the appraisal to understand the real property.
Okay, we have a recommendation. Do I hear a motion? Got a motion to accept from Mr. Phillips. Do I hear a second?
Second.
Second, Mr. Johnstone. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, like sign. Next.
Item number 11, 2012-007741. This complaint was filed by a consumer potential homeowner and alleged the value of the unit was not supported. Complainant alleged that he obtained a couple of second opinions on the appraisal and that the appraisal was deemed as out of the norm, atypical. The respondent sent a very lengthy response to the complaint, stating that due to the subject property's GLA size, it was clearly noted and explained in the addendum of the original report of the reason for the expanded market. The respondent stated that in valuing river or lake properties, it has always been required to expand the market with atypical gross and net adjustments. The respondent stated that all adjustments are based on buyer-owner preference items, contributory value, influence from over-improvements, and functional utility, etc. Add adjustments are reasonable, according to respondent. Respondent stated that his report is reasonable and well-written for the intended use, based on the fact that the owner-client purchased the site vacant and built a house to support an estimated market value. The report is clearly marked restricted use. The report states that the owner should obtain additional opinions of value from trust builders prior to any offer to sale or purchase. Respondent states that complainant is simply attempting to purchase various properties under market value with support from his appraiser. The review conclusions are as follows. The improvement section is lacking in details on the updates and modernization of the property. The sales comparison approach contains large adjustments without any explanation. Reconciliation was not consistent with the chosen indicated value. In the cost approach's land value, there was no discussion or reference to the work file land sales in the report or reconciliation that derived the indicated value. There was nothing about site value except a list of sales that is difficult to read or follow to understand the method used to arrive at the indicated site value. The appraisal report contained no disclosure of scope of work performed or not performed. The appraisal does not adequately summarize the scope of work performed. The appraisal report indicates the report is both a summary and a restricted use appraisal report in different places. The reviewer found that the appraisal report was lacking in completeness and adequacy due to the above cited issues. Respondent has been licensed for about 21 years with no prior disciplinary action against him. As such, counsel recommends that this matter be closed with a letter of warning regarding the cited issues stated above.
You've heard the motion, heard the recommendation. Do I hear a motion?
Motion accept.
Motion to accept, Mr. Wolfman. Do I hear a second?
Second.
Second, Mr. Covington. Discussion? Mr. Johnson?
Just a couple of points on these bullet points. If it is in fact a restricted use report, then the only ones here that I see that are really problematic from the standpoint of reporting would be the disclosure, the scope of work discussion. Even in restricted use, you should have a scope of work outlining that. In terms of in the report itself, about the improvement detail and all that, restricted use would not require many of those things. The last bullet point, summary and restricted use, that that's problematic from the standpoint of whether they were. Looks like he probably cloned something back and forth. I would probably, with this gentleman or person, whoever, 21 years of experience, I would even be inclined to back it up to a letter of caution, because it was an intended user, knew what they were getting, and unless you understand what's in a restricted use, you can't. I mean, you're going to have the entire work file to really understand it, and you're not supposed to understand it unless you're the intended user. So I would like to amend it to close with a letter of caution.
Do I hear a second? Got a second, Mr. Phillips. Discussion?
No,
Green?
I'm slow. What's the difference between a letter of warning and a letter of caution?
With warning and caution.
Well, caution is a little less. Warning is you didn't get hit as hard. You just got
No,
hit.
they're both equal in a sense. Am I correct in that?
I don't know if there's, I don't see much difference. Like I said earlier, caution and warning, it's all kind of the same thing to me, but I think Mr. Johnstone expressed that he felt like it wasn't as much of a blow to them if you just worded it as a letter of caution.
Well, I thought we had said the hierarchy was instruction, caution, warning.
I kind
And
of
so
agree.
unless it's not, I don't know.
I just sort of feel like they're all the same. That's just my opinion.
They're kind of all the same because none of them are certainly mentally, they seem to have a connotation of,
It won't change the wording.
Only thing in this case, I think that the complainant doesn't even understand what a restricted use is. You know, the intended user and the client does, and you don't have to have all these explanations in the report. So it'd be very difficult to review a restricted use report without the entire work file. You couldn't review it.
the biggest problem with the report was that in one place, and I think it was just probably a cloning thing, in one place it said summary, in another place it said restricted use. It was very evident from the report that it was restricted use, but there was two places that it said two things, so you can see how that could.
I would like to amend it to dismiss it.
Okay, we got a motion.
I'll remove my amendment.
Okay. We have a motion there to just dismiss, without a dismissal. Can I get a second to that?
I'll second that amendment.
Okay, and then we got an amendment
May I recommend you just withdraw the motion and make a new one, because this is just, that's a long chain of stuff.
Okay. Well, everybody, whoever made a motion, just withdraw, we'll just get right.
We're gonna call it a three.
Okay.
Reset.
Okay. All right. Would somebody like to make a motion on this matter?
I make a motion that we dismiss.
Okay, got a recommendation dismissed, second by Mr. Johnstone. Any further discussion on this? Mr. Green?
I'm sorry, I'm totally sorry, but I think dismissing this is taking the consumer's complaint way too lightly. I think the appraiser needs to know that there needs to be maybe some education done with his client, her client. And I'm wondering if this might fertilize a problem down the road for this appraiser. I have trouble supporting complete dismissal.
Okay, let's go for the question. All those in favor of the letter of dismissal, signify by silence. Correct? You just gonna dismiss it?
The recommendation currently is to dismiss it. Ms. Boyd?
Correct.
Motion is
Johnson.
to dismiss
Correct.
this one.
Right, okay, all those in favor say aye. Opposed?
Okay.
We got 3 nays and 1, 2, 3,
Could you
4,
roll call,
5.
please?
Okay, great.
Nay.
Got 3 nays. Everybody else approves? Motion carries. Next.
Hold on, let's. Hold on. Okay, got it. Thank you. I'm sorry. It's taking me a little bit longer. Yes. Yes, I got it. Thank you.
Okay. Item number 12, 2012003441. This complaint was filed by an appraisal management company. It alleged that respondent communicated a misleading appraisal by failing to analyze busy street influence, using inappropriate comparable sales, and failing to analyze and verify data. The respondents in a response stating that the subject property location is not a negative factor on the subject's value and does not adversely impact the marketability of the subject property. The street is recognized as a premium location of residential properties and is considered to have the prestige and desirability that other streets in the same market area do not have. Respondent stated that MLS data was used and that all sales included in the report were arm's length transactions. Respondent states that all sales were accurate. The increases in values were normal increases in the value of the area properties at that time because mortgage funds and lending were readily available and market prices increased from the substantial amount of activity within the real estate markets. Respondent stated the appraisal report was appropriately developed, adequately documented, and well supported in its determination of value, and no unacceptable appraisal practices were engaged in during its development. The reviewer conclusions were as follows. The appraisal report makes no mention that the subject property is on a busy street. The appraiser used sales in a superior location in an area where older, smaller homes are being demolished to build much larger homes. The appraiser used sales on a much larger lot and made a very small adjustment to the subject of the size difference. The appraiser did not provide any comparable lot sales respondent has only been licensed for a little over 1 year and has been disciplined for violations in the past. Council recommends the authorization of a civil penalty in the amount of $1,000 to be satisfied within 30 days of execution of the consent order, and the 30-hour sales comparison approach course to be completed within 180 days of execution of the consent order. These terms are to be satisfied by consent order or formal hearing. Civil penalty should serve as a sufficient economic deterrent, while the corrective education should assist the respondent in becoming a more effective appraiser, thereby protecting the interests of the public.
I'd like to make a motion to accept.
Motion to accept, do I hear a second?
Not second.
Got a second, Mr. Phillips. Discussion. Hearing none, all in favor say aye.
Aye.
Opposed, like sign.
Okay, item number 13, 2012-007811. Complaint was filed by an outside agency and alleged that respondent used inappropriate comparable sales data on his appraisal of a home. The respondent stated in his response that he was requested to do an exterior appraisal on this property, and that with the changing market, the search was focused on sales within the last 6 months of time and finding similar sized homes within the subdivision, the neighborhood, and within the competing subdivision. There had been activity within the subject subdivision. However, in respondent's opinion, the sales with sale dates over 6 months are not reflective of the more current market. Respondent stated that at the request of the lender, corrections were made on several items. In addition, sales within the subject subdivision dating back to April 2011 were considered, and 3 were added to this report with a reduction in the opinion market value. However, respondent stated that he did not change the date of this appraisal, as this was a new assignment under these PAP regulations. This file contains 2 separate appraisal reports. It contains an original appraisal report along with the revised version. The reviewer conclusions are as follows. The neighborhood market trends and factors are not appropriately supported. The market trends information presented on the first page of the report is inconsistent with the market conditions addendum. The sales comparison approach in both the original and revised reports do not provide adequate reasoning or support for opinions and conclusions presented. The report lacks proper discussion on the adjustments, subject's relationship with the area sales, and a lack of support indicating the sales used are from similar or competing market areas. The site value is not supported in either report due to the lack of analysis of area sales and sales presented. The cost approach is not properly supported by the information in the work file or presented in the report and could not be recreated by the reviewer. Previous experience was not discussed or reported. The revised report makes no mention that it is a revision of a previous assignment, nor is there any mention of the previous report. The reviewer found that the inconsistencies throughout the report diminish its reliability. The information provided and the opinions reported in this appraisal report do not provide adequate support for the conclusions rendered. Based on the information in the appraisal reports, neither the original nor the revised report contains sufficient information to enable the client and its human users to receive or rely on the report and understand it. As such, Council recommends a consent order authorizing a civil penalty in the amount of $500 to be satisfied within 30 days of execution of the consent order, and a 15-hour residential report writing and case study scores to be completed within 180 days of execution of the consent order. These terms are to be satisfied by consent order or formal hearing. Civil penalty should serve as a sufficient economic deterrent, while the corrective education should assist the respondent in becoming a more effective appraiser, thereby protecting the interests of the public.
You've heard the recommendation, do I hear a motion?
Vote to accept.
Move to accept, Mr. Green, do I hear a second?
Second.
Second, Ms. Johnson. Discussion on this? Discussion? Hearing none, all in favor say aye.
Aye.
Opposed, like sign.
Okay. Item number 14, 2012-017211. This complaint was filed by a fellow practitioner, appraiser, and alleged that respondent reported a sale that did not exist in the sales comparison approach of an appraisal of a residential property. The respondent stated in his response letter that the comparable sale in question was a for sale by owner and was a confirmed sale through courthouse records. respondent's statement included an MLS number in the sales grid that was a mistake, but respondent claims it was not fraud. The reviewer conclusions are as follows. The appraisal report contains no opinion of exposure time. The appraisal report fails to summarize and support the following opinions and conclusions. Opinion of site value, opinion of adjustments in the sales comparison approach for effective age, analysis of the sales contract relating to contract contingencies. The appraisal report fails to summarize the opinion of highest and best use, both as approved and as vacant. The appraisal report fails to state whether prior services have been performed on the subject property within the previous 3 years and the report certification. The appraisal report has sufficient violations to support lack of due diligence resulting in appraisal services having been performed in a careless and negligent manner. The appraisal report has sufficient violations so as to result in insufficient information for intended users to understand, resulting in conclusions that are potentially misleading. And the work file submitted did not contain any data to support the site value opinion. The recommendation is the reviewer found several violations of use type that would warrant disciplinary action against respondent. Specifically, the reviewer found there was no record or verification of a sale of one certain property as stated in the appraisal report. However, there is a property located at a slightly different address that sold as identified in the appraisal report. This discrepancy is the sole basis for this complaint being filed by complainant. According to the reviewer, the complainant, a review appraiser, has not performed due diligence to discover this minor oversight on behalf of the original appraiser and chose to call this fraud. The appraiser is guilty of violating Standard Rule 1-1C in rendering appraisal services in a careless manner, but is not guilty of fraud in the opinion of the reviewer. Additionally, review of the appraisal work file did not discover any land sales or other documentation to support the site value opinion. This is a violation of the record keeping rule. The respondent has been licensed for a little over 5 years with no prior disciplinary action against him. As such, counsel recommends a consent order authorizing a civil penalty in the amount of $500 to be satisfied within 30 days of execution of the order, and a 15-hour residential report writing and case studies course to be completed within 180 days of execution of the consent order. These terms are to be satisfied by consent order or formal hearing. The civil penalty should serve as a sufficient economic deterrent, while the corrective education should assist the respondent in becoming a more effective appraiser, thereby protecting the interests of the public.
Heard the recommendation, do I hear a motion?
Make a motion to not accept the recommendation, but rather just send a letter of warning.
Second.
We have a motion to send a letter of warning, and we have a second to that by Mr. Johnstone. We have a motion, is there discussion? Hearing none, all in favor say aye.
Aye.
Next.
Item number 15, 2012-025-211. This complaint was filed by an appraiser and alleged the respondent did not pay appraisal fees and was guilty of removing an appraiser from its appraiser panel or otherwise refusing to assign requests to an appraiser. In addition, according to the office records of the Tennessee Real Estate Appraiser Commission, respondent is not registered as an appraisal management company in Tennessee, nor was it registered as an AMC at the time of the activity that is the subject of this complaint. The complaint file includes copies of several invoices from complainant showing unpaid appraisal fees for services rendered, with the most recently dated invoice showing June 25, 2012. To date, this office has not received a response to the complaint from respondent. The complainant did not provide proof of the respondent removing an appraiser from its panel nor refusing to assign requests to an appraiser, thus there is insufficient evidence to prove that allegation. However, complainant did provide proof of unpaid invoices for services rendered between April 2012 and June 2012 at a time when respondent was not registered as an AMC. This failure to pay for services rendered constitutes a violation of Tennessee Real Estate Appraiser laws, as well as constitutes unlicensed activity on the part of respondent for acting as an AMC without registration to do so. As such, counsel recommends the authorization of a consent order authorizing a civil penalty in the amount of $8,000 to be settled by consent order or formal hearing. The civil penalty amount constitutes 7 separate counts of failure services that are unpaid. In addition, this civil penalty constitutes a $1,000 penalty for unlicensed activity on the part of respondent.
Make a motion to accept.
Got a motion to accept, do I hear a second?
Second.
Got a second, discussion? Hearing none, all in favor say aye.
Aye.
Opposed, like sign.
Item number 16, 2012020291. This complaint was filed by Appraisal Management Company and alleged that respondent submitted a fraudulent copy of his real estate appraiser license. According to the complaint, respondent submitted a copy of his license in April 2012, while this license was expired. According to the office records of the Tennessee Real Estate Appraisal Commission, respondent's license had expired on February 12, 2012. Respondent did not renew his license until August 15, 2012. Thus, respondent submitted a copy of his license during the time when his license was in fact expired. The respondent stated in his response that the facts presented by the complainant were true. Respondent stated that due to several different hardships in his life, he has not been working much and allowed his license to expire. Respondent admits that out of desperation, he presented an invalid license to the complainant in the hopes of generating enough income to complete his renewal requirements. Respondent states that he regrets this action and that he has been an appraiser in Tennessee for over 23 years and has never received any complaints or disciplinary actions filed against him. And the recommendation is respondent admitted to knowingly submitting a fraudulent copy of his Tennessee real estate appraiser license to an appraisal management company during a time when his license was expired. This constitutes a violation of the ethics rule as well as the laws of the Tennessee Real Estate Appraisal Commission. However, respondent did in fact renew his license sometime after this submission. Respondent has been licensed for over 20 years, so he should fully understand the laws and rules of his profession. As such, counsel recommends a consent order authorizing a civil penalty in the amount of $1,000 to be satisfied within 30 days from the execution of this order, and the suspension of respondent's real estate appraiser license for a period of 45 days. If respondent does not pay the civil penalty in full, his license will be indefinitely suspended until such time as payment of the civil penalty is made in full. Terms of this consent order are to be settled by consent order or formal hearing.
You've heard the recommendations, do I hear a motion?
I'll make a motion.
Got a motion, Mr. Phillips, do I hear a second?
I'll second that.
Second, Mr. Covington. Discussion?
Just a comment. It seems like the suspension would be counterintuitive to what we're trying to accomplish.
I was thinking the same.
I mean, he's gonna have a hard time paying his fine and learning his lesson if he's not working.
At the same time, he started off the walking good fraudulent activity as his first offense. I mean, he knowingly altered his license to get work.
Oh, it was,
He
altered
altered his license.
oh, I think you're right.
He changed his license expiration date and turned it into an AMC so that he could get enough money to take some continuing education courses.
Go rob a bank, change your license number, either way.
He started off on a whopping good time to me, that's pretty serious offense for the first.
Yeah.
Yeah.
That's about as serious
It's up
as
to
it
you,
gets.
though. It's
It is your
your
decision.
discretion.
So I'd like to make sure everybody understands at this point what, I agree to accept as you.
No further discussion.
All in favor, say aye.
Aye.
Opposed, like sign.
Chairman,
No, excuse me, hold on. Mr. Wolf?
can we take a short bathroom break?
Sure.
Yes.
And thank you.
Yes. Have a break here for 10 minutes, 10-minute break here.
That's clever.
Back in order. Okay. Ms. Baird, you want to continue, please?
Item number 17, 2012-013-521. Complaint was filed by an appraisal management company and alleged that the respondent misreported the gross living area and used inappropriate comparable sales, which affected the value opinion of the subject property. It should be noted that this complaint was filed in 2012 on an appraisal that was done in 2008. The respondent stated in his response letter that the neighborhood and comparable sales were appropriately described, but that he made an error by including square footage from the barn in the gross which affected the comparable sales and listings selected and ultimately affected the value indication. Respondent stated that this was an isolated instance and he has had no other complaints in 20 years. The reviewer conclusions are that the appraiser included the barn in the heated living area of the house and in turn inflated the value by including the barn in the square footage. The appraiser neglected to analyze and verify the data by including the barn in the square footage. While the respondent did admit and the reviewer did find that respondent did inflate the value by including the barn in the square footage, it is the opinion of the reviewer that the original appraiser did not intentionally mislead the user of the report. Rather, it was an unfortunate mistake in the report that led to an inflated value. In addition, the reviewer found that there are few sales of similar homes in this area, and the sales used represent the best available. The respondent has been licensed for about 19 years and has had no disciplinary action against him. Respondent admits this error was a mistake on his part. In addition, this complaint was filed almost 4 years after the appraisal was completed by respondent. As such, council recommends that this matter be closed with a letter of warning regarding the issues surrounding the inclusion of the square footage of the barn with regard to the inflation of the value indicator.
Well, we hear the recommendation, hear a motion,
Move to accept.
move to accept.
Second.
Mr. Varela, second by Ms. Johnson. Discussion. Hearing none, all in favor say aye.
Aye.
Opposed, like sign.
Okay, item number 18, 2012-011-851. This complaint was filed by an appraisal management company and alleged that respondent communicated a misleading appraisal report of a residential property which had commercial zoning without disclosure or adequate analysis of highest and best use. Defendant alleged that respondent used inappropriate sales data and overvalued the subject property. The respondent stated in his response that his participation in the completion of this report was as a trainee under the supervision of another appraiser. Respondent stated that zoning information for the subject property was acquired by contacting the county zoning and planning department, as no online zoning maps for that county were available at the time of inspection. Respondent claims that he was told by the county that the zoning was residential, the use of the property at the time of inspection was residential, and the county land use in the tax records was residential. As such, its highest and best use on the effective date of the report was its legal use as a single-family residential home. Respondent states that the comparable sales used in the report were appropriate and that the report stated that due to a lack of a more recent, more suitable sales, the respondent was forced to extend his search beyond 6 months and 1 mile. Former supervisor and signing appraiser on the appraisal report let his credential lapse in 2012 and is beyond the period where he may renew the credential. The respondent is identified on the certification page of the URAR form as, you can see there in parentheses, state certification number. He did not clearly identify on the appraisal report that he was a trainee at the time of the appraisal. He signed the transmittal letter to the client electronically and no supervisor is indicated on the letter of transmittal. On the market rental data page, the respondent is identified only as appraiser with his signature. And I've included some statutory language there. I can read that if you guys want me to, or just, okay. The reviewer conclusions were the appraisal report noted an incorrect zoning classification for the subject property. The report classifies the property as residential when the correct zoning was a C2 commercial. The appraisal report contains no explanation as to the residential use of the property in a commercially zoned area. The appraisal report fails to analyze the previous sale of the subject property. The appraisal report fails to analyze the adjustments made for age on any of the comparable sales listed. Recommendation and reasoning. The reviewer found that the appraisal report contains several violations of USPAP which would warrant disciplinary action against respondent. The respondent was inappropriately identified in the appraisal report as the appraiser and does not make clear to the client or intended users of the report that at that time he was a registered trainee in violation of Rules 1255-01-.12, 4H, and 9. The respondent also violated USPAP in the above noted analysis of the zoning as the report contained supervisor is no longer an appraiser and has no right to renew, so it does not seem necessary to open a complaint against the supervisor. Since the respondent was a trainee at the time, council recommends that this matter be closed with a letter of warning, identifying the above violations and indicating that future violations may result in discipline.
Okay, we've heard the recommendation. Do I hear a motion?
Make a motion.
Make a motion to accept, Mr. Covington. Second? Second by Mr. Phillips. Discussion.
I think this is a fairly egregious offense, and I think the complaint should be flagged in case I know he doesn't hold the license right now, but I think the complaint should be flagged for any future application toward getting his appraisal license. If he comes back and wants his license, this is a serious offense to me. And,
Yes. Supervisor.
oh, I thought that it said that he was a registered trainee and that that he
The current
didn't currently hold a
respondent
license.
is a certified appraiser.
Right, he is a certified appraiser now, the respondent.
And so he's claiming no responsibility for signing the report as the appraiser or any of the contents in the appraisal.
He was a trainee at the time, and he had a supervisor at the time the appraisal was done.
But he presented himself in the report as the appraiser.
He did. Correct.
To me, that's appraising without a license in this state, and I think that's a very serious offense.
We have
I
a,
think, I agree with Mr. Mullin. I truly do.
I-
To let this person off with just a warning.
I think it's akin to the case that we had earlier where the guy changed his license date. I mean, it's basically the same thing as practicing without a license in this state.
It says trainees must uphold use value. That's in that, it's in the red.
I'd like to, I don't know if we change or amend the motion or just present a new motion with a $1,000 civil penalty.
I'd like to say this, just from my own experience, I had trainee, or when I was a trainee, my supervisor wasn't a good, I had to relearn the appraisal profession once I removed myself from him. I would do my best to try to put an appraisal report together. I hand it over to him to review it, send out, sign, finish it up, get it out the door to the client. I probably missed thousands of things. Now, knowing what I know now, I probably gave him a bag of junk to deal with. What he did with that, I don't know what he did with that, but my name was on it as the trainee. I understand your position here is him signing as the appraiser, but man, I fell victim to somebody who was just interested in making money, pushing reports out the door. I was young, I was new, I didn't know what I was doing, and I didn't know the difference. I thought I was doing my job the way I was supposed to be doing it. But I got on some do not use list that took me forever to get off of. It took me forever to gain my reputation back. I got thrown under the bus for something. I didn't even know what was going on. I didn't even know what I was doing. So I don't want to kill this guy because of my own experience, but I understand what you're saying, that he said I was the appraiser. I get that. But just hear my side and then maybe let's have some discussion with that.
I'll say I don't think a $1,000 civil penalty is a death penalty, and we're not suspending or revoking his license, or unless there's further discussion. I don't think that it approaches that. You know what I'm saying? I mean, just in my opinion.
let me ask a question, if I may, pardon me. If we go with that, however, that will have to require a consent order, is that correct?
If you go to...
If we go with the fine, that
Yes.
will require a consent order, correct?
Correct.
For something that happened before he became a licensed appraiser, correct?
Certified, yes.
Because he's now a certified residential.
Correct.
So this will go onto his file, but it'll be prior to him ever becoming an appraiser. So when he reapplies to renew his license, will he have to check on that I have been disciplined?
I
That was the question.
All right, the question is.
The appraiser.
All right, the question, Nicole, is this. Okay, when I was a trainee, I screwed up. Okay, I screwed up. Then I went on ahead and got my license to appraise. Okay?
Certification.
So now I have my license. All right. Now after the fact, I'm going to have to sign a consent order saying I screwed up back here when I was a trainee. When I reapply for my license, and I have to fill out a form that says if you ever had any disciplinary actions, am I going to have to say yes, or am I going to have to say no?
Yes.
Yes.
So I'm going to have to say yes, but really I didn't do it when I was licensed. I did it when I was trying to learn what I was supposed to be doing.
Correct.
Well, he
So
was
I'm
registered
just-
at the time.
Huh?
He was registered at the time.
Yes, correct. I agree. And I'm just concerned, I just don't want to create any problems for this person.
I think it is a serious violation.
I agree.
That's the reason that persons who want to become appraisers are required to take principles, procedures, and use pattern before they even register. Before you can even begin day one, you have to at least have the core knowledge. And that's one of the reasons why you have to act under a supervisor. The supervisor in this situation is going to be impractical to pursue for a variety of reasons.
Yeah,
The trainee should have known better.
I agree.
The form was that URAR form, which contains some pre-printed language. And you will see experience interviews every month that we meet, where trainees have to identify their significant appraisal assistants, and they identify themselves as trainees. Well, in that line that they signed on, this appraiser didn't indicate that they were a trainee. They just signed their number, and they didn't indicate TR, RT, or trainee, or any of that language. They just put their name on the line. So that's the violation that you're discussing.
And I'm afraid if we don't address this in serious terms, it's a way for trainees to practice as an appraiser and get by with it. There's a reason we have trainees and we have that training period.
Mr. Johnson?
Thank you, Mr. Chairman. I want to have to agree with Commissioner Covington on this. From the standpoint of this supervisor is no longer even practicing. They're out of the business. They're not even in the game. And there are a lot of supervisors out there that do not know how to be an appropriate supervisor, and the training is terrible. And sometimes, as he says, those reports are prepared and then they're sent up the chain in a residential mill, and maybe some clerk there put it out, and does that excuse the training? No, it doesn't. But by the same token, you can't go back on the supervisor. They're out of business. Obviously, they weren't doing something right, or they'd still be appraising. This person has moved on, and I think what his statement was about how he had to fight and battle his previous supervisor. And with Norman's comments, this gets upgraded to a consent order. All of a sudden, it's disciplinary. It's the check, yes, I've been disciplined. As long as it stays warning, caution, or instruction, they can breathe a little bit. I would like to, personally, I like the recommendation of council.
Well, at this point in time, is that the only motion on the floor?
The motion currently is Mr. Covington is the motion, Mr. Phillips is the second to approve the recommendation. There was discussion about the $1,000 civil penalty, and I did not have a
But there's
motion and a
never a
second for
motion
that.
made on that, nor a second or anything like that. Okay. Okay. Hearing no further discussion, all in favor say aye.
Aye.
Opposed?
Nay.
One nay vote. Okay. Motion carries. Go ahead.
Item number 19, 2012-015-191. This complaint was filed by a consumer homeowner and alleged that respondent communicated an appraisal with numerous errors which caused the subject property to be undervalued. Complainant alleged that the many errors and inaccurate data in the appraisal report the poor perception of the subject property relative to the other properties in the neighborhood. As a result, complainant was unable to refinance all debt on this property and has suffered financial loss. In his response, respondent disputes all of the complainant's complaints, stating that certain errors were made but were corrected in his revised report to the lender. Some of these errors respondent contributes to software glitches. Respondent states that his amended report to the lender addresses the complainant's concerns. The change report are corrected plat map, one level versus two, party board versus wood siding, and price per square foot in the sales comparison approach. Respondent states that none of these changes affected the credibility of results. Respondent states that he is confident that his appraisal report shows both compliance with USPAP guidelines and Tennessee laws and rules. Respondent also states that review of the sales comparison analysis show that the value estimate is accurate and defensible. The reviewer conclusions are as follows. The information contained in the neighborhood boundaries section is inaccurate. The first appraisal report contains inaccurate statements in the improvement section. There were several errors in a number of stories, foundation, and exterior walls, form, and check blocks. The first report had under foundation the concrete slab block checked, while the second report had both the concrete slab and cross base block checked. The site dimensions and total site area were inaccurate. The site area in the comparable cell grid is inaccurate and missing prior cell data on cell number 2. The report contains no lot sales or site value, development, or reconciliation as report for the site value, and the second report date has the same report date as the first report. The reviewer found that the report is lacking in completeness and credibility due to the multiple report errors on the part of respondent. The respondent has been licensed for over 20 years with only one previous disciplinary action against him. As such, counsel recommends consent order authorizing a civil penalty in the amount of $500 to be satisfied within 30 days of the execution of this consent order, and a 15-hour residential report writing and case studies course to be satisfied within 180 days of the execution of this consent order. These terms are to be satisfied by consent order or formal hearing. The civil penalty should serve as a sufficient economic deterrent, while the corrective education should assist the respondent in becoming a more effective appraiser, thereby protecting the interests of the public.
You've heard the recommendation. Do I hear a motion?
I'll move to accept.
Motion by Mr. Green. Do I hear a second?
Second.
Second by Mr. Johnstone. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, like sign.
Okay, item number 20, 2012-025-441. This complaint was filed by the administrative staff of the Tennessee Real Estate Appraiser Commission for failure to submit biennial certification as required by the laws and rules of the Tennessee Real Estate Appraiser Commission. On November 26, 2012, respondents submitted the appropriate biennial certification as requested by this office. So, since respondents submitted the appropriate certification forms to this office as requested, counsel recommends this matter be closed with no further action.
I've heard the recommendation. Phillips makes a motion to accept. Ms. Johnson seconds it. Any discussion? All those in favor say aye.
Aye.
Opposed, like sign. Motion carries. All right, let's see.
Okay, oh, I'm sorry. Yes, don't leave off number 6, which we deferred.
Yes.
Page 7 of the report. Of you, I think. Sorry, hold on. Now we're ready. I think that the question on number 6 had to do with the intended user of the appraisal report. And documentation says that the purpose of the appraisal is to estimate the amount due to the property owner as a result of acquisition of all or a portion of the property for a proposed right-of-way project. So I'm assuming that,
That's the purpose. Does it say who the intended?
well,
Who the-
property owner.
Property
Intended
owner?
use as a property owner.
Who's the client?
Well, I think it was the attorney for the property owner, correct?
Yeah, according to the appraisal reports, I have Laura Betty, our chief counsel, for the reports. I pulled up the actual appraisal report, took a look at it, and the client who requested the appraisal is the attorney for the property owner.
So this was for the property owner.
The
It wasn't
attorney-
for the, it wasn't
Yeah,
the
the
TDOT.
attorney, yes.
It was for the attorney of the property owner. They requested the appraisal report.
Okay. Was it in a form that was a TDOT type form, or was it a separate written report.
It appears to be a separate written report.
So it appears to be the appraisers.
The appraisers own hired. And so in terms of the market value definition that was stated in there, they're using a definition of market value that would be used most likely for lending purposes, or did they use a Tennessee pattern jury definition? I can look at it.
The definition of market value they took actually from used pattern, which I do not believe is the appropriate source for, and I'm not an expert on that, so I've never done a right-of-way appraisal.
Okay, so-
That's what they cited.
So let me see if, okay, so I can, I'm done with my question. Brief recap. One, used an unrecorded plat. Property owners own appraiser used an unrecorded plat. Two, they used a wrong definition of market value. And then the sales compressor approach was unsupported and not completely adequately completed. I'm okay with council's recommendation. I move to accept council's recommendation.
Okay, we have a motion to accept recommendations on item number 6, case 201103006. I can't continue.
It's item number 6. It's 201103061.
81, my 8 got covered over, I couldn't
Oh,
read it.
that's
Hey, could we recap what council's recommendation is?
yes. The recommendation was authorization of civil penalty in the amount of $500 and a 30-hour course on general appraiser report writing and case studies. And those will be settled by consent order or formal hearing.
Let's see, Mr. Johnston, you made the recommendation, I believe we accept. Who made the second? I didn't hear. Who seconded the motion? Do I hear a second on it?
Second.
Got a second, Dr. Barala. Okay, now we can get into discussion.
Mr. Johnson,
Yes, sir.
you said something about the course,
That's right, yeah.
and wondering if that was going to be added.
Yeah, you're right. That's a good point. I forgot about that. That course might ought to be something that's right away related instead of just general related. Good point. I would accept that as an amendment to that, is that a right away course.
Hold on just a second. Nicole?
I would need it to be a very specific course. We have to write those into consent orders, and they have to agree to them. So we need to know exactly what it is. Generally, I help with the courses, and most of the courses that we recommend are qualifying, so they have an exam.
Yeah,
If you want to require a specific IRWA course, I mean the exact title of that course,
We
and
can
we
get,
need to
can
ensure
we,
that has some kind
can
of.
we make the motion and substitute that later?
What if we just said,
After we find out, I think it's course 401, I believe, or something like that.
I think it is too.
I think it's course 401, it's called right-of-way, acquisitions, and that course covers appraising for right-of-way. I used to teach this course at one time, Nicole, so just trying to think back on it.
Mr. Chairman, how hard is it going to be to get that course? How often is it
Right.
offered?
If
I
we take a
think-
5-minute break, I'll go look it up. But
Oh, okay.
we just want to make sure it's
Sure.
correct.
Okay, real good. Let's take a 5-minute break then if you do that, okay? Now,
Sorry.
that's okay. Mark, off the record, to answer your question, Bill Medley.
Yeah, Bill.
He was very active in the right-of-way association. Move on.
All right. I'm sorry, I had to go print that out. Quick. All right, there's several courses International Right-of-Way has. They have 7-hour easement valuation, 16-hour principles, 32-hour principles of land acquisition, ethics in the right-of-way 8, reviewing appraisals 8, 801 United States land titles.
Unfortunately, I think the
16.
32-hour course, Nicole. would
Here's
come-
one. Valuation of partial acquisitions for 30 hours.
Are those-
Principles of real estate negotiations, C15 or C200 for 15 hours. Principles of real estate appraisal, C400.
Does it say where they're located and or when they're offered?
We don't approve locations, we approve the school and the course. They can operate in Hawaii and it's approved. It's just a matter of,
You can give them extra time.
Can I?
Okay.
I'd like to withdraw my original motion and restate it, a new motion.
Wait a minute, let me check it directly here.
My original motion was to accept council. I'm going to restate it and deal with this issue.
Who seconded the motion? Who seconded the
did.
motion?
I did.
Dr. Burrow?
Dr. Varela.
Okay,
I'll withdraw the second.
we have the withdrawal on both, so the floor is now back open.
Okay.
I move that we accept council's recommendation with the revision that the general appraisal report writing case studies course that's suggested to be completed within 180 days of the consent order be revised to include something that pertains to right-of-way and eminent domain appraising, and leave it at the discretion of council and executive director to approve a course that would be suitable for that.
I think that might be too much discretion.
Too broad.
It's
Too
Because I could
broad.
approve a 7-hour course, that would be
Well,
really
it's, I guess what I'm trying to do is get something that they can actually find that's being presented, within a somewhat of a regional area. They don't have to go to Seattle for 40 hours. So I was trying to keep, rather than having to come back to this body, say maybe at a minimum of 7 hours or
No.
something.
One of the reasons why we should generally recommend qualifying courses is because they get held often. People trying to get the courses, they're held periodically all over the country, and because many of them are available online. If you're going to require a course that's more specific in nature, like a right-of-way course, I would recommend making it fairly specific, not necessarily the exact course. You could recommend 15 hours of courses in partial acquisitions. And that way they can still have some discretion on what they want to take, but it has to be at least 15 hours in length. Just give us more specific the parameters of what you want. So it's just not completely open-ended, because
The problem that I see happen is this. Number one, this individual needs to have a course in partial acquisitions. In order to take that course, you're going to probably a minimum of 30 hours in order to get a partial acquisition course. You could probably get one of these courses through the Appraisal Institute or through the International Right-of-Way Association. The problem is, where is it going to be held? There is a problem. We don't want to impose upon anybody a cost that gets prohibited. But by the same token, if somebody's going to put themselves up that I am qualified to do this type of work, they need to have the education. And if that means if they want to do this work, they got to expend more than you do just be a typical general appraiser, then maybe that's what we need to require. I don't know. But, I get concerned about this because I do a lot of condemnation work. And I cannot begin to tell you how many times I sit there and say, how did this person ever get here? And I've been there too many times. And so consequently, I don't want to be overly, I do not believe the commission wants to be overly burdensome to the appraisers. But by the same token, if they're going to specialize in a certain field, they should have the expertise to be in that field. That's just my general
We've had some
comments.
problems with settlers in the past where either a course was required that didn't exist, like a 15-hour sales comparison approach course doesn't exist.
Exactly.
They're 30-hour courses. Or it was a course that was so specific that and then the course provider chose not to offer it anymore, and then how do you comply? So within those parameters, I think those courses are held fairly often, at least once a year.
This one right here meets the bill. I'd move that we accept the $500 civil penalty within 30 days of execution of the consent order, and then a valuation of partial acquisitions class consisting of 30 hours be completed. And we could give them up to a year if it's a problem finding the location.
We have the motion made. Now, do I hear a second?
A second.
Got a second, Ms. Johnson? Discussion?
30 hours.
That's what this course is, so
Yeah.
it'd be easy
That's
to
in the
find.
right.
Got it. Got it. Thank you so
All right.
much.
Any further discussion? Okay, all those in favor say aye. Aye. Opposed, like sign. Okay. All right. Does that conclude the legal report?
Yes, that concludes the legal report.
Okay, Director.
Thank you, Mr. Hall.
May I ask a question for a second, please? Commissioners, it's now 12:25. We probably got at least another hour probably to go, 30 minutes to an hour
Yeah.
to go. Do y'all want to stop and eat, or do you want to keep going?
Keep going.
Okay, no
I
problem.
always underestimate. I'm really not going to argue as much as
I
you
just
do.
want to make sure that everybody's comfortable with this. Okay.
All right.
And if anybody, if we need to take a break
It
along
doesn't
the
hurt
way,
my feelings if you eat while I talk.
eating is permitted during discussion.
Yes.
Okay.
The first item, I just wanted to share some good news. Good news is always welcome, right? A new office assistant has been engaged, and they will be starting on Thursday. And his name is Dennis O'Brien. He'll be starting Thursday with us, and we're very excited. He's going to be working all of my boards, and he's already been told it will be intensive training, and he's going to be trained to do everything I do. So he will be my right-hand man. Good luck, yes. And when he cracks and quits after like the last one, we'll let him, we'll let you know.
Are you still looking for another one also?
I am. I'm going to try to persuade our deputy commissioner to allow us a second position. About a year ago, one of our positions was allocated to the cashier's office to fill an urgent need, and they took the position rather than the person. I mean, they took both, but they were just supposed to borrow the person, and they took the position, so I have to actually get the position back in order to hire somebody, which is a human resource thing, which probably none of y'all care, but that's why it's sort of more of a hurdle.
It seems like it might, do you need Chairman Hall to go to that meeting with you to emphasize how much you need this personnel?
Let me start the conversation. I might at some point request that the commission write a letter. But
Well,
it's sort of, let's get no first.
as
Before we, it's not a problem yet.
If I may, as chairman, I recently sent an email to the members of this commission reflecting on the fact of my concern about the amount of work that Nicole, you've been asked to do. Because we've got a lot of changes coming down the pike. We need somebody to stay on top of this 100%. I can guarantee you that no member on this commission can stay on it 100% like you can. And so we depend on you a heck of a lot, and you're doing a tremendous job. I'm just concerned that these other governmental agencies might say, wait a minute, she's working for me, she can't do this over here, she can't do this. And all of a sudden, next thing you know, 2015 is here, and we're still operating off of 2011 rules. You know, I just want to make sure that we stay ahead of the curve on this thing. And I think so far we have been able to do this. You need your input, and you're keeping us there. And I don't want to do anything to cause us to fall behind or not do what we're supposed to do. So consequently, I think anybody on this commission will talk to anybody you think we need to in order to make sure that you have our support. So I just want to let you know that. And get it on the record.
I very much appreciate that. The Assistant Commissioner for Regulatory Boards has been very kind, and I don't want you all to think that I don't get support. One of the trade-offs to taking on additional boards was so that I was sort of a one-man show for a while, and that was too much stress. Not that I couldn't handle the work coming in, but that I couldn't take a day off, I couldn't have vacation time, and that was a stressor. But now there's a second director, and though her primary duties are to cover other boards, if I need a day off, she covers me, and if she needs a day off, I cover her, and we share some administrative staff, and they cover everybody. And so even though I still handle the lion's share of the workload, just knowing that, you know, if I take a day off, somebody's got my back and somebody's taking care of business, that very much matters. And I know that the administrative assistant we just engaged is fully going to be dedicated to the tasks I put at hand. I really think that's going to make a big difference in my resources and my time. I've made it a personal goal this year to do more public outreach, which means I'm going to have to rely on my administrative staff to take some of the day-to-day business off of me. Next month, I am going to speak in front of the appraisal, the local chapter of the Appraisal Institute. I agreed to do that, and I'm going to keep my promise. Myra asked me to come to their annual business meeting. I want to remember what it's called. Anyhow, the Appraisal Institute locally is having a meeting down in Brentwood, and I'm going to go and talk to them about the 2015 requirements. Just Myra and I have been doing a lot of back and forth discussions about this, and she put in right before, actually she got our word out before I got our word out on the 2015 requirements, because it was easier for her to do a newsletter than it was for me to, and she got it out for us without making it. Actually, she put it in very politely the way I asked her to. I said, don't quote me because the law hasn't been written yet, so put it in as the AQB requirements, and so that people know that it's coming, but don't put it in as the commission said we're going to do this, or the commission's. Myra's been very great about doing, you know, sometimes when you deal with professional organizations, they can overstep sometimes and start taking things out of context, or in their newsletter that they heard or said. She has been 100% very helpful and cooperative, and so I'm going to go talk to their group and get the word out. So that's step one. Lost my train of thought. So anyhow, getting back to the hiring thing, I don't think we're going to get a no, but if I do meet some resistance, I will contact all of you. If I think that there's going to be a problem, I'll let you all know. I'm making this a regular report in my director's report to where we stand and the workload as to what's going on administratively. If I start to think we're buckling under, it's going to get more work for all of you too. When we get closer to 2014, and again, this is me using my crystal ball, we have about 240 trainees right now. They're all going to want to upgrade before those requirements hit. So how many experience interviews is that? I mean, that's going to be a ton right before it. Those of you who are around, Mr. Phillips can definitely talk to this, and Dr. Brillam surely remembers it.
We were doing like 4 trainees at a time.
Well,
Yeah, it's crazy, every month.
well, I can appreciate this, having served on the original commission.
Yeah, it gets to be a lot a month.
I remember well what we went through.
We had like 30 a month at one time. And that was the 2008 requirements, and I think it's going to be much more this time because that college degree requirement now being a done deal, if you will have a college degree, I don't think they'll have any alternative since the segmented approach is going away. They're either in or out before 2015.
That's a lot more administrative. I mean, yes, we'll be doing a lot more interviews, but we're going to have a lot more administrative as well.
Yeah, it's going to be a lot coming in. That's one of the reasons why I'm getting a year ahead of it, a year and a half ahead of it, training someone else to be able to. And I have a good administrative assistant right now. She's really good at, catching things. She's a good second set of eyes to review applications, but we've got to get a couple more people on this trained to go all the way through it, so that I'm more of a final set of eyes rather than the sole set of eyes on the application.
I think you just pointed out my concern, because you're talking about all these candidates coming in that we are going to have to review. Well, prior to us getting to that point, they got to come through you.
Yeah.
Which means that you're going to have 240 where you can divide that by 9 up here. So
Right.
consequently, you're going to be low below it too.
Okay. But I do this all day, every day, so
All right. Okay.
don't worry about me.
All right.
For now.
For now. I'm confident. This one hasn't changed.
Hold on.
Lift your right foot.
Put your
I
right
appreciate
foot
that.
out.
Put your foot down.
Item 2, real estate appraisal laws and rules are in need of revision for the laws and background checks. Last one, we discussed that at length, but obviously it's still important. That's one of the very important items. The formal hearing that was scheduled for this month has been continued to March 11th. This one I do need a vote on from the commission. We had one date set in March 11th, on March 11th. And I wanted to know if the commission wanted to meet for a second day in March to handle this matter, because it's going to take 2 days. It's a lengthy matter. If you want to make March 11th and 12th, or do you want it to be March and April? Or March and May, depending
Well,
on how you
I
want to do
had,
it.
I had also asked for the recommendations of the commission as to those dates, whether or not they'd like to go ahead and meet 2 days in March and skip the February meeting. That the general consensus at that time was that they'd rather go ahead and have the 2 days in March and skip the February meeting. And at that point in time, Ms. Point has already informed me she can only be there for 1 day. Mr. Walton has also indicated there might be a problem with him attending at this point. I'm not going to say he's not going to be here, but I think he has some issues of trying to schedule it. So consequently, let's make sure we got enough people here for the time being. Let's just say they will not be here and see if we can do it. If the answer is yes, then we'll move forward. If the answer is no, then we'll have to back up and see.
One other consideration, if you cancel the February meeting, we have just today, with this week, this last week, we got 3 applications to upgrade in. So that would mean that those 3 persons would be held for 2 months if we cancel the February meeting.
Okay, still, yes,
Mr.
sir.
Hall, thank you. Justin Joseph, Litigation Counsel. In furtherance or to dovetail Ms. Avers' comments relative to the formal hearing, as the commission may very well know, this matter was originally set for today as well as tomorrow, and a part of the day on Wednesday if we needed it. It's a very massive and lengthy matter, replete with expert testimony on our part, and I would like for there to be the maximum number of appraiser members present, if at all possible. If we could not do it on 2 days in March, we have to skip a month, which I hate, but if need be, we have to do it that way. I'd also like to say that if in fact the commission's will is to do it for 2 days in March, the sooner I know that the better, because of a little bit of difficulty we've had with the Secretary of State's office's Administrative Procedures Division, the division that assigns us judges. We only have 1 judge assigned for March 11th. If the commission's going to go for a 2-day meeting in March, the sooner I ask the scheduling assistant give us a judge for the second day in March, the better prospects I'll have of getting that.
Can I make a comment?
Kevin?
If Nancy and Tim are here, we're not gonna have a quorum.
You still could, because you need 5 people to have voting quorum, and a majority of those have to be appraisers. So as long as there's either 3 and 2 or 4 and 3, education, public, AMC. I know you're an appraiser also, but you're not considered an appraiser member. As long as you don't outnumber or tie them, the appraiser members,
Well,
then
if-
you have quorum.
If Mr. Walton cannot be here, we'll have 1, 2, 3, 4 versus
Three.
3.
So you still have quorum.
So we would have.
And if one of us got sick or something,
I can stay
you still had 3, and then one of them could recuse himself to have a
Right.
full one.
Right.
If you had to. I'm just trying
If
to.
you had to.
And if my dates get changed, I'll
If
come
his
for last
dates
time.
get-
My dates should get changed. I'll come.
Let's ask Mr. Joseph, though, I mean, would you rather have this, would you rather have 4 appraisers and do it in March, or postpone it till April and have 6 appraisers?
Well, the reset date we got right now is at least for March 11th. We've already got an order going in for that date. I simply wanted to make sure that pursuant to Tennessee Code annotated J, we're able to make our statutory minimum insofar as our quorum is concerned. So that doesn't make a whole lot of difference to me. I would like for us to do it 2 days back to back if at all possible, because in that way you wouldn't have to have your recollection refreshed after a whole month. I wouldn't have to get a transcript partially prepared, ready for the second month. There are a lot of other practical considerations, but again, sometimes we have to do things.
Well, another consideration would be a conflict. So if you only had so many here, and one of us got conflicted out, then you reset as well.
Well, it would really almost have to be 2 of you, because you only need 3 for 4. 3 appraisers and 2 public.
Is that the meeting, that's a 2-day or a 3-day we're talking about?
In March,
We'd have to
it'll be
do
2
this
days.
and.
It's the commission meeting, and if you look at the back of the director's report, I did put down what the commission meetings currently are. You can revise your schedule as long as I can get the rooms. I held, just tentatively, I held a 2nd day in March just so that we wouldn't run out of rooms. Sometimes the boards here are fighting for rooms between each other, and I didn't want funeral to get it, so. Funeral board is often conflicting with the appraiser commission on room bookings. They do just like
Parking.
the same weeks.
And
parking, yes.
So what you're saying is we'll need to meet again in February, is that correct?
What I'm saying is, I have to be here either way, so it's really up to you guys. I'm going to be here in February. If you want to come in February, that's awesome. If you do not want to come in February, that's that much less work for me to do in February.
Well, as I have told you and have indicated to my vice chairman over here, I will not be available on that date. So, whatever they want to do, fine with me.
On the February,
Sir?
on February.
Correct.
So you would need to appoint, if neither of you, if you want to hold a meeting and neither of you are going to be there, you need to appoint a temporary chair or temporary vice chair or somebody to run the meeting.
Well, the question is, I think, Nicole, do we absolutely have to meet that day in order to process candidates or trainees or anything, or can it wait until March 14th? I realize it's a month later, but
You can wait.
It's a short,
You are only bound to meet quarterly.
and it is a short month.
yeah.
You want to entertain a motion?
It's up to you all.
Yes, let's get a motion on meeting in February.
I would move that we not meet in February and we postpone till March, and we have March slated to be at least a 2-day, maybe a 3-day meeting.
Okay, we have a motion, do I have a second?
A second.
Got a second?
I'm sorry, what's
Any
the second?
discussion?
No,
Discussion? Hearing none, all in favor say aye.
Aye.
All right, there you go, Nicole.
Thank you. The rest is going to be very brief. As you can see, I still have on the report our 2010, 11, 11, 12 budget information. I just am keeping it on there so you can see the figure totals. The 2012-13, it's not very reflective because it's only a couple months data. The pattern is just to show you kind of how the ratio or pattern of expenditures to revenue. The figures look a little different. The revenue looks high, but that's because we took a big income change because of the AMCs coming in 2011. So that's why it looks high that year. On the next page, the complaint totals, very relevant data. You can see the numbers are kind of progressive 2010, 2011, 2012 increase pattern. 2009 was when the 2008, 2009 was when the economy crashed. So you can see that we're almost back up to that same level again. Yeah.
When you go to meetings with deputy,
Good data. Good
good
data.
data?
I'm not as dumb as I look.
We're in the trends here.
Our license data has been updated on the next page for appraisers, certified general, certified residential. We're holding fairly steady at about 2066 was the total last Friday. We've been hovering right around 2100, give or take a few. Appraiser courses at 350, temporary practices also hover right around 200 at any given time. Appraisal management companies, we have 157 currently. We have 260 pending renewals right now, which is about par. And we have 130 appraisers who have inactive credentials, which would not be reflective of the above numbers. So you just kind of keep them at any point, they could shift back into the active credential point. In December, I met with the Department of Financial Institutions to discuss an option for doing the fingerprinting and background checks, known as the NMLS system. They do it for, they do background checks and fingerprinting for the mortgage brokers and originators. Although it was very nice, it was a great demonstration and they made a gigantic fuss over us, and I very much thank them for it. I don't know if it's a feasible option right now because no other states have bought into it. It's definitely something I'm keeping on the radar, but there's about, from what they reported to us, about 6 states that are considering using the NMLS, but I don't know if it has a real feasibility option if the other states aren't going to buy into the system. One of the nice things about, when we use the National Registry is all the states buy into the system, and that's why it sort of works, is you check everyone's credential data because everyone's using the same system. Well, if some appraiser states are using one system of running background checks and fingerprinting, and some states are using a different one, and we're not really getting a benefit out of, I don't know if they were going to...
Did we ever follow up or pursue the idea that this background check and fingerprinting and everything, if the state has already done a background check on you and already fingerprinted you and everything like that, do we have to still do that again? Do the appraisers still have to do that again?
Yes, you'll have to do it again.
I was thinking about the cost involved for the individuals, having to have this done every time you turn around. I don't know how much it is. I don't know how much it costs.
It'll depend on how the legislation is written again. We'll come back to that. But ultimately, your recommendation was at the last meeting to the legislatures that it be initial applicants and upgrade applicants, which is the bare minimum AQB requirements. And we're just going to have to comply with the minimum AQB requirements, which means that they are going to have to do it.
Just had a brainstorm. All these states are going to go through this 2015 change. When you're a member of the organizations, what is back the compliance language and procedures and the fingerprinting and all that stuff.
Wow, that would be great. I am not going to address that this month.
Well, I mean, that's just.
That's a great idea.
Yeah, I'd like to make a motion.
I'd like to make a motion to let it be socially inappropriate.
But wouldn't that, I mean, that would be efficient, would it not? If
Yeah.
the states all pursue the same track?
It would be, not all states are members of ARROW, so that's a, but, yeah. It's really hard, and they attend the ARROW meetings too. It's really hard to get all states to buy into a single concept.
No, you're kidding.
Right, because even if the consultants came back, then every state would have to ratify the consultants.
You can get that done.
Yeah.
Yeah, if you can get it done,
Yes,
that would be
okay.
terrific. I would recommend that for the April ARROW conference, that the commission recommend Mr. Green and Mr. Covington be sent to the ARROW conference in addition to me, so that they can share their ideas and gain from the knowledge of ARROW, so that I am not the only one there. And if we can make it happen, I will get behind you. I will support your idea. If it can,
Well,
if it can
please
be done.
please notify Mr. Green and Mr. Covington when those meetings are and wherever they will be held, so they can start making arrangements, please.
Would you be interested? Okay, terrific. The only other two items on this thing is one is an interpretation of your rules. I did, and I put it in your meeting documents as, it's in your rules, but I also put it in as additional documents for, just for reference. We had a school submit a question. They are scheduled to renew a course that they had. Sorry, there we go. And they wanted to know if their renewal fee could be waived because of language in 1255 -2.13 under fees, which reads, the commission will not require a fee from state-supported universities, colleges, and junior colleges which provide courses for qualifying or continuing education.
Okay, what page are you reading from?
It's page 16 of the evaluation of appraiser education rules.
Okay, thank you.
It's the very last page of those rules.
Okay.
And it's item number 4. They are a university, but they're a university in Michigan. Does state in that rule mean the state of Tennessee, or does it mean any state?
What is legal counsel?
That's why we're.
It doesn't, I mean, it's not
Fee will be-
not clear in the rule. It just says the commission will not require a fee from state-supported universities.
Well, I think we
Say-
need to respond to these people and tell them they misquoted it because they got a misspelled word in here. So consequently, say with truth, P-R-O-V-E-D, instead of provided, that they ought to pay the $104. They can't exactly get it correct. They're just supposed to be a college.
I want to.
They actually already
I don't
paid
think
the
relook is a
$104.
word. Is relooking a word?
So it's really a request of do we return their money?
We just need to interpret whether state-supported universities refers to Tennessee state-supported universities or all state-supported universities
What's in front
all
of
over.
Is there anything preceding in that paragraph that would lend you to make one conclusion or the other?
I have no clue.
That's all it says in, I mean, you can see the previous page. That's all it says in that section.
Mr. Chairman,
Yes.
my opinion would be at this point, the way that reads now, I believe that covers, I don't care what state you're in. I mean, it's kind of hard to misread that. You know, they've already paid their $104. My opinion is to give them $104 back. If we want to amend that and change from this day forward, any out-of-state universities will be applicable to the fee. I think that the way it's written, I believe, we wouldn't be doing the right thing by taking their money.
Okay, we've heard this comment. Is that a motion, or we don't have a motion on the floor at this time, do we? So
Yeah, I can make
we
that.
don't have a motion on the floor at this time?
No,
do we?
sir.
Okay, Mr. Covington?
Yeah, I'd like to make a motion to return the $104.04 that Northern Michigan Union University has paid for their qualifying continuing education. And maybe after further discussion, look at maybe changing out-of-state licensing fees versus in-state.
Okay, we got a motion by Mr. Covington, second by Mr. Phillips. Discussion?
I think we should just go ahead and amend the motion and say that from this date forward, the language will be clarified that it's strictly in-state.
You know, let's,
We
I
either
tell you what, let's go
rule
ahead and
every
make
state
it,
university.
let's just deal with this motion first, and then we can change it if we want to later on.
Okay, but just for clarity purposes, we would have to do a rule change in order to make that.
Now,
You
and
can
a rule,
interpret your rules. The commission, it's the commission's ability to interpret your rules, but you can't issue two different conflicting interpretations. So if you're going to interpret it one way, then it would be really inappropriate to interpret the other in the same, especially in the
Right,
same
so
vote.
what I'm saying, let's keep keep them separate, keep them separate. We got a motion right now to return to $104.04, so let's just deal with
Just make
that.
that motion like that, and cut all that
Yeah,
off.
just right there, so that's all we're gonna deal with, okay? All right, all in favor, say aye. Aye. Opposed, like sign. I might make a comment. If this had been Central Michigan, I'd have been okay. So if anything the Chippewas do, I'm all for it. Okay. Sorry about that, folks, okay? Now, Mr. Walton, do you want to make a motion?
no, I think we've already taken care of it.
No, we did not.
We want to change our.
So we want to change our
We
rules.
just did that one
We have to
case.
do rulemaking, we're going to do
It would be-
rulemaking soon, so.
It would be a process, we'll just add that to.
Just put that on our to-do list.
Okay. All right.
I guess to change wording, you would have to do a rule change, but
Yeah.
just to interpret it, you wouldn't do that.
So you're gonna go ahead and make a note of that for the rule changes? Right.
She's all over it.
Okay.
So that's not going to make us unfair on the national scene and get us in trouble with our federal friends.
I don't think so. We're doing it.
I want to be friends with the vets.
Okay. All right.
They can take the cookies.
Okay.
The last item on here is introduction. We did at the beginning of the meeting of the policy managers, but they asked for an opportunity to discuss, to have an opportunity to talk to the commission. If that's okay.
Anybody, any other business to come before the commission?
I just want one thing.
Phillips?
Ms. Abrams wanted me to review the standards and write a letter to the Appraiser Standards Board, had comments on 2014, 2015 years back. If anybody has something, please get that to me. The deadline is next Friday, January 25th. Send in our comments. I've read over this. The major thing that I see, you probably read it too. The major thing I see is they're going to retire standards 4 and 5. They're going to go from 3 reporting options to 2 reporting options. And those options will be the appraiser report, which resembles almost a summary report. Then you have your restricted, not restricted use, they're going to change to a restricted appraiser report. And based on my interpretation is that the way they guide these reports is by the scope of the work. In other words, if you need a self-contained, you can handle it in the scope of the work and consider the intended user. So those are the main things I saw unless you saw something different. And if you need a copy, do you have copies?
I can get copies for
Address.
everyone. I think I emailed it out to everyone, but I can
Okay.
get another one.
But
No, I don't need
if you want me to comment on these, please let me know by sometime next week. So, do you have anything additional you want to add to the exposure? Any comments?
I commented publicly to the last one, and pointed out a couple of little things, and they actually took it out from the last one to this one, so my concerns are minimal. My major issues were with the draft report stuff that they were doing, which seems like it's sort of dead in the water now, so. Okay.
Are you ready?
Yes, please.
All right, now for some real excitement. I just wanted to take this opportunity because there's enough new members to explain who we are and why we're here. And as a refresher for some of you, which I've heard comments several times today, that some of you are returning. I thought you were new, but you've been on this commission or this board before, so welcome back. As you know, in 1989, we had the savings and loan crisis, and that's when Title 11, the Financial Institutions Reform, Recovery, and Enforcement Act, was enacted, also known as FIREA. In short, Title 11 mandated that all real estate appraisals utilized in connection with federally related transactions must be performed in writing in accordance with uniform standards by individuals whose competency has been demonstrated and whose professional conduct was subject to effective supervision, hence the licensing boards. To accomplish those mandates, Title 11 charged the Appraisal Foundation, which, as you know, is a non-profit corporation with the responsibility of establishing the uniform appraisal standards, which is USPAP, and the qualifications, which we now have the appraisal qualifications board. So the Appraisal Foundation is the parent organization for those two entities that you talk about a lot, and you follow their recommendations or their requirements for the criteria. And Title 11 also provided that the states had to establish licensing programs. There was some that were already in place, but in order for appraisers to be eligible to do appraisals for federally related transactions, all states had to establish at least that criteria or that classification. At the same time, Title 11 back in 1989 established the Appraisal Subcommittee to monitor the states to ensure that their practices and procedures were in compliance with Title 11. And it also required the subcommittee to establish the National Registry, which you're very familiar with. I also wanted to just point out real quick, we gave you these great books, our annual report. Page 7 also is a spot to get a little bit of our history as to who we are and why we're here. In addition, this page 7 is going to also kind of give you a summary. Back July 1st of 2010, I know you've heard of this too, it's been the most sweeping reform since the original enactment of Title 11. The Dodd-Frank Wall Street Reform and Consumer Protection Act was put into place. I know you've already experienced one of the changes that came from Dodd-Frank, and that was the increase in the National Registry fee, which we put in place in January of 2012. And so it went from $25 to $40. Some of the other things that the Dodd-Frank reform is going to do is the Appraisal Subcommittee will now be overseeing states in regard to the registration of AMCs. We now look at the states, although we did this somewhat before, as Nicole knows, the changes of Dodd-Frank now gave the subcommittee the ability to look at the states to ensure they have adequate funding and staffing. We will have to maintain a national registry of AMCs. We are to establish the national hotline, which is is in process right now.
You know what the time frame is on that? I don't mean to interrupt.
On the hotline?
Uh-huh.
Well, I think we're looking at spring. If all goes well, we're looking at spring. It's been a long process of getting there, but I think that's the goal right now. And we still don't have any idea how it will impact the states. You know, and we're hoping that the states will kind of keep track too, so that we can see, you know, as Nicole mentioned, you've already seen a trend of your cases going up, so we really don't know how the hotline will.
How to staff for that, and how do you know, how's that gonna work? You guys are gonna get those phone calls or those complaints or issues or matters to handle, and just take them one by one and just take them as a group?
Well, one by one, the way I understand it.
It's actually a referral. So they call in or they go on the website and answer certain questions, and it's like directed traffic. We go here and we go here. This one goes to here and here. So we don't, at this point, the phase one, we won't be following up or anything like that. It's strictly referring the complaints. And
To a
it's
certain
only-
department.
Right, and it's only complaints against appraisal, either use capital
Or undue influence.
From the influence, exactly. Right.
So it's only those two things that we have been going to refer.
And at some point, will a human being talk to another human being and address that issue and resolve it in whatever manner?
Well, that's up to whoever it's sent to. If it's a complaint against an appraiser, when it comes to your board, then it's up to you to deal with it, to determine whether it's, just like your complaints now, is it legitimate to take action? or
So
is it
you'll
something-
redirect those things back to us?
Yeah, and
Okay.
you make those decisions.
Okay.
And if it goes to a banking agency, then they make that decision.
Okay. Sorry.
And that's, once it gets into place too, I mean, there may be some tweaking.
Right.
But I know that the staff that's working on it is really trying to cover every possibility, so we'll see. We're keeping our fingers crossed, so. But we will also let the states know when it goes up. I'm sure that there's gonna be a notification so that you are ready, just in case. But like I said, there was, many changes that came about with the Dodd-Frank. And just for your reference too, back on page 47 of our annual report, if you would want to see is the red line version of all the changes that came about to Title 11. And some of the other more important things that I wanted to mention real quick as a result of Dodd-Frank, that I know Nicole keeps you up to date on everything that is coming, but July 1st of 2013, which is going to be here before we know it, Dodd-Frank had the mandates in regard to reciprocity. I looked at the policy that you have in place. I mean, when I originally looked at your statutes and regs, I thought we might have a problem here in regard to the reciprocal policy that will be required by Dodd-Frank. But then looking at your policy, I think it's fine in that regard. And ask me if you have questions, because right now I'm just assuming that you know what I'm talking about. The other thing that happens July 1st of 2013, you almost need a chart to track all this, is states that have the state license level for the trainees and supervisors will have to adopt the minimum APB criteria. In the past, it's not been a requirement for the states to adopt the criteria, but July 1st of 2013, it will be. Here again, just based on my initial review, which I'll talk more about in a minute, I'm not sure if you've got everything you need or not, but I think you probably do, knowing Nicole. So those are two things that are coming up very quickly in regard to the Dodd-Frank. The other thing, and I know you're up to date on, and we've just provided these as another reference, you know all of the things that are coming with the APB criteria by 2015, fingerprinting, the degree requirements, just supervisor changes in regard to how long they have to be in good standing and things like that. If you have any questions as you're working through making those changes, we're more than happy to look at your statutes and regulations on both and provide any comments that we have, just to make sure, because our goal is to have all the states ready for 2015. So please, as you're working your way through those, let us help in any way we can. And again, I can't tell you, she is so in with what's going on, so I'm not too worried about you. If you want to question anything she's doing, feel free to call me.
Well,
I'll have to give you my business card. So in order to carry out the ASC's mission under Title 11, as you know, we do periodic reviews of all the states. And generally, we have 55 jurisdictions, and we go in every 2 years at a minimum. In some states that may need additional follow-up, we may go in on an annual basis. But generally speaking, we're in a jurisdiction every 2 years. In addition to the Title 11 language, we also have what we call policy statements, and they were issued to help the ASC carry out their duties. Now, the policy statements are not currently in the annual report because they're in the process of being revised. They went through a public comment period that ended November 29th, I believe. And I don't know, did you provide them the draft back then?
I did.
So everybody had an opportunity to look at them and to comment. Right now, the ASC is in the process of looking at all the comments and taking into consideration, the discussions that came in, and I guess we'll be issuing. Okay, so that's what I mean, the subcommittee. I'm not sure what the expected date is, though.
Depends on what they decide.
So we'll keep you posted. There was a lot of good comments that came in, and so they are taking all those comments into consideration before they come out with the final version of the policy statement. So we will post on that. Did you have a question?
I was thinking they might find it interesting to know the members of the subcommittee.
Oh, yeah.
And the new members specifically.
I will refer you. I must have missed that on my note here. So I'm going to refer you to the. Oh, page 11. I did miss that on my note. We have 7 individuals that are consist of the subcommittee. And as you can see, we've got the Office of the Comptroller of the Currency. We don't have the Office of Supervision because that merged with the OCC. We have the Department of Housing and Urban Development, Board of Governors, the Federal Reserve, FDIC, the Federal Housing Finance Agency, NCUA, which is on the next page, and the Consumer Financial Protection Bureau. Those are our 7 members who sit very much just like you do. We make recommendations to them based on our reviews of the states, but they ultimately make all decisions. In that regard, is that what you wanted me to tell them?
And the chair, I think, at least to my knowledge, for the first time in my memory, is an appraiser. So the chair of the present subcommittee right now is an actual appraiser. So I just found that very interesting.
Well, no, since this was printed, it's actually Peter Gillespie down with the Department of Housing and Urban Development. And then while we're talking about the subcommittee, if you look on page 13, you see our large staff. We have added, since the printing of this publication, we do have, because Claire is now the Regulatory Affairs Specialist. We have Brian Kelly, who is an Administrative Officer. We did hire an Attorney Assistant, Dan Rhodes. And then we're in the process of hiring a financial analyst. So eventually we'll be up to 13, right? You probably met him at the last. He was there briefly. Because he had just started it. It was like his first day.
So this is the eighth compliance review for Tennessee, and we're kind of doing this a little bit backwards this time. Generally, we go into a state and we spend the first couple of days in the office, and we do a review. There's 7 areas that we look at when we're in the state: the statutes and regs, temporary practice, your application process, national registry, reciprocity, education, and enforcement. We look at all these 7 different areas, and there's a lot of work involved in getting ready for our arrival, as Nicole can tell you, and I do want to thank her because she gets everything we need. But she sends us piles of documents, minutes for the last 2 years, all the credentials that you've issued, education, enforcement, and statutes and regulations, and then we randomly go through the information that she has sent, and we select files to be reviewed while we're here, which is what we're going to be doing the next 2 days. Like I said, generally we do that first, and then we give our preliminary thoughts about what we've seen with the program to the board. This time we're going to do it backwards. I'm presenting to you right now. I'm telling you everything's the last time we were here 2 years ago, we were in compliance. So, but we will be spending the next 2 days going through those files that have been pulled, and then Nicole will pass on to you what our thoughts were at your next meeting, or if you would like a conference call, whatever works best for you. But we will be here for 2 more days, so she needs to hang out with us. And while I'm thinking about it, also I do want to say on behalf of the agency, thank you very much to board members. Your service and dedication is very much appreciated. We know it's a thankless job, and you make a lot of money doing what you do. But thank you very much for what you do for the profession as well. We enjoyed observing your meeting today. She told me to make it brief. I'm going, where's my normal notes here?
I did in the information packets with all the board documents, I didn't include their the big findings options
Yes.
that they can do, just so that you all knew, in compliance, not in substantial compliance.
And it's back. It's also in
My
this book.
brain's
I mean,
locked up.
this is a great record. Back on page 61, it kind of tells the difference. Now, the only thing I want to point out is when the new policy statements go into place, we are coming up with a different rating system. And I don't know if it will impact them, depends on when the policy statements go into effect, but not for this review. Okay. I didn't know how that was going to work. Because what happens next is once we get done here, I will prepare a preliminary report based on our thoughts on how the program is doing, and it will come back to Nicole. It's basically a staff-to-staff correspondence, and the state has 60 days to respond. And typically why we do that is if there are issues that need to be addressed, the state has an opportunity to either correct it or at least provide us with information on how you plan to correct it before it actually ever gets to our subcommittee. When they see it, they see what our findings were and what your plans are to correct, and then they'll issue a final report. So it usually takes several months to get to the final stage. Any questions? Yes.
Agree?
For the ramifications, I know on page 59, there's a lot of states not in compliance or not in substantial compliance. And like the goals are here. What are the ramifications if you're consistently not in?
Well,
You become not.
yeah. See, the way our rating system has worked in the past, I mean, you've got insubstantial compliance, not insubstantial compliance, and not in compliance. And so if you had any areas whatsoever, really, you became not in substantial compliance. It's one of the reasons why the subcommittee is changing the way we're doing the rating system, because it is kind of misleading in a sense, because there might be some that are not in substantial compliance that only have two findings or minor findings. So it's kind of misleading in my opinion, but it's been the way it's been
So most
evaluated.
people, I hear you say most people.
Most states.
They become compliant.
Correct. And really, in this scenario, I mean, there's only one state that is not in compliance, and that is definitely not in compliance.
Way not.
Way not.
And the difference with they're not in compliance, and this will take effect in July 1st for reciprocity. If the state is not in compliance, then the other states do not have to accept appraisers from that state for reciprocity. You can, but you don't have to. Because the not in compliance is where we're really looking and they're on a very short time frame of us going to compliance, trying to get them in compliance, because if not, then it could lead to other types of sanctions or even
And you can imagine, just, it's not us, but if it were us, the outcry from the licensees, if suddenly they couldn't go to other states because we weren't in compliance, they would cry out to the legislatures and say, hey, something's going on with the regulation. So not being in compliance for whatever the reason may be, whether it be the laws, rules, administration, processing, complaint processing, whatever the reasoning may be, once the licensees are affected by the outcome of it, the outcry will be huge. States involved shall remain nameless. Thank you.
And states can have a more open door policy. I mean, just because the state is not in compliance doesn't mean that can still accept them, but it also gives you the way that the Dodd-Frank language is written. That's one of the prongs. If the state is not in compliance with the appraisal subcommittee, that is a reason that you do not have to recognize it for reciprocity.
So Florida's still having problems, huh?
Yeah, really. Yeah.
And look at our website and look at the compliance review for anything that's been determined. The preliminary part, like we're doing now, and before it's actually issued, that is not covered. But once, and especially once it's in here, but once it's, the subcommittee sends out their final report, anyone can go on our website and see what that report says.
Any other comments, questions? Approved?
Well, you mentioned the hotline, one of the buttons is under the influence. Yeah, I would just make a request of you all on your messaging. We've had a problem with complaints regarding undue influence and how to prove it. We've gotten those complaints, but appraisers don't understand you gotta back it up. And it would be helpful, since you're gonna be sending all those to Nicole, you might, on your message line, you might say, if this is a complaint from an appraiser, please advise, you need to have these things lined up to help prove that you're being unduly influenced. It's a request.
It's a great idea.
We might put something, because they're going to essentially be just a referral system. And they're going to refer them to probably, in my imagination, I don't really know, I don't sit in their offices, so I don't really know, but some kind of link to our website where our complaint portal lies. So we may need to, and that's, I think, one of the groups, or the work groups that we talked about last time, we might need to revise some language on our website where it says filing a complaint, submitting these documents for this type of complaint would be advisable or requested, or I don't know how you want to phrase it, but
Required, yeah.
Required, or whatever. I think to require it, we'd have to put it in the statute, but requested, certainly, we could close a complaint, because that's the main thing, is we'll have to close it if we can't prove a violation. Somebody said, well, that guy was bullying me.
Well, maybe it needs to do with Danny Wiley told one of his clients, says, "I'm sorry, you're not on my approved list anymore."
I think we could just send the hotline to Mr. Green. We'll just forward the hotline.
I'm just saying the feds.
Second.
You'll second it.
All in favor? To have it be
The ayes have it.
helpful
That's
to
right. You got it.
that. In 6 months or so, we plan to have a phase 2 where we're really going to go in and look at numbers. Because while we're not collecting any private information, we're going to be collecting what type of person or entity it is that's complaining, what type it is against, and that sort of thing. And we hope to get feedback from the states and agencies. And so if you're seeing something, that if we could add something, some little blurb to what we're putting out there on our website or on the call center itself, that would be helpful. That's the time that we really are going to look at and say, okay, how many are we getting? Do we need to keep this open? Do we need to have a different call center somewhere more than just in our office?
And they're very much trying to work within that same issue of trying to get 55 jurisdictions to agree on any one thing. Like some of the states
And the banking agencies.
and the banking agencies. Some of them won't accept anonymous complaints. We accept it. Some of it has to be in writing. Some of it has to be notarized. Some of it.
Yeah, we tried a uniform complaint form.
That was shot down. We'll accept anything except it just has to be in writing. That's just so you know. We'll take complaints as long as it's specified who it's against, what the allegation is or allegations are, and back it up. You know, some type of evidence. I mean, we'll accept it even without the evidence, but it'll probably get closed if there's no way to prove it. You know, so we'll accept it if it comes in writing in any form. You know, I don't care if they put it on a napkin. Now, how far that will go is a different question entirely. You know, certainly that's why we have complaint forms, because they're, in my opinion, they're tools. They're not meant to be prohibitive to consumers. Use them and make it difficult for them to file a complaint. It's meant to be a way to organize their thoughts and figure out how to communicate to the commission what they're complaining about.
Okay, anybody other comments? We have a motion to adjourn.
So moved.
Second.
All in favor, say aye. Opposed? Stand adjourned.